doesn't operate as a checklist and a set of factors.
Okay, so please explain to me the test.
The test is objective reasonableness, and it is like that is how you can encapsulate it. However, the court has helped us in some respects, and they helped us in some respects by pointing to types of things that matter for the objective reasonability test. Okay, so the first are a set of principles that you've elaborated, that it's an objective test from the position of the officer. In other words, it has to do with what an objectively reasonable officer would do given a situation. That the test is one that we consider taking in mind the fact that officers have to, in the line of duty, make split-second decisions. Okay, these are all things that you've mentioned that the Supreme Court has told us guide our inquiry. One quick correction: they haven't yet ruled, the Supreme Court that is, on officer-created jeopardy hazard, unreasonable creation of officer-created jeopardies. Right? That's a point that I've talked about, but every time I talk about it, unlike what you represented to Destiny, I say that Barnes v. Felix has explicitly not held as a matter of law that we should incorporate that. So just to be clear, that's one of the main reasons I was frustrated, is because you represented me as having a position on officer created hazards that I explicitly and deliberately disclaim every single time I bring that doctrine up. So that's one of the reasons for the frustration. But there are additional...
May I?
Yeah.
Real quick. You have to understand that, much like an officer in the field, I'm receiving information from 10,000 different sources, and also they become an amalgamation of the same movement. So much like Destiny has identified the anti-fans and the snarkers as this like monomaniacal Leviathan villainous element that he has accused you of being in reference to harassing him. And much like my audience is making fucked up, crude sexual jokes about you, and if you read them, they would probably be upsetting. Much like people tell me that your chat doesn't like me and thinks I'm a retard and all that kind of stuff. The truth is that it becomes an amalgamation, and so you personally might have met like all of these caveats every single time, said that it's not decided, it's not incorporated, et cetera, but what people in your audience or your political tribe are doing is they're representing it as if this is the law of the land, and as if the law enforcement officer can be held accountable under this legal concept now. And that's how they're arguing it in chats, that's how they're arguing it in discords, that's how they're arguing it on Twitter.
Well, first of all,
so it might not be you,
okay,
but that's what your tribe is arguing.
So my tribe is also arguing, if you consider my tribe, depending on what you think my tribe is, that they're not even officers, so they can't even be there in the first place. My tribe is also saying...
But there's stronger and weaker arguments, right?
Yeah, so
and
like, if you just go by
in my opinion, a stronger argument.
I understand, but you can't just be like, oh, well, your tribe says it, therefore I can say Pisco says it.
Sure,
you can't
but I
do
might
that.
have mixed you up with your tribe, so my apologies.
Okay, so
it was an earnest R-slurred mistake, not an attempt to malign your public reputation.
No worries. The thing is, I don't think it's unreasonable for people to argue that it be applied, because I think it would be insane not to have that standard. And so even though it's not the law of the land, it's the law of land in some places, just not in the Supreme, with respect to the Supreme Court. They haven't ruled definitively on it. And I think it would be insane for it not to be the overall law of the land. However, just on the discrete point, I'm happy to move on from that. All right, so we've analyzed some principles that are incorporated into the objective reasonability test. The fact that it's not purely subjective, the fact that it's from the officer's position, the fact that it takes into account the officers having to do split-second decisions. But there are additional things that we're told to look at. And this is from cases like Graham v. Connor and follow-on cases. So I want to point you to a case called Kingsley v. Hendrickson. Okay? If you Google right now, Kingsley v. Hendrickson, and I'll read from it. You don't have to Google it. This is a case from...
I was about to say, I'm not going to. Read it to me, please.
This is a case from 2014 in which the Supreme Court is analyzing the use of force in a case according to the Graham v. Connor objective reasonability test. Now, unlike, if you guys remembered my conversation with Chud Logic tried to be like, it's the Graham factors, mate, the Graham factors. It's not a concrete list of factors, and Kingsley itself makes that clear, as well as Graham v. Connor. One of the reasons why you can't just look to a fact pattern that's similar is that the Supreme Court has told us that reasonability turns on, quote, the facts and circumstances of each particular case. So it's not enough just to have a similar fact pattern if there are potentially distinguishing facts in the given case. But notwithstanding, that we are given some things to look towards. And in this case, Kingsley, this is what Justice Breyer, writing for the court, says. And by the way, this was later incorporated in a follow-on case called, let me just get the name of it for you, Lombardo versus City of St. Louis. So this is what they say, quote, considerations such as the following may bear on the reasonableness or unreasonableness of the force used. The very first thing that Breyer puts in this opinion, quote, the relationship between the need for the use of force and the amount of force used. Okay? You as an officer were also trained on reasonable necessity, correct? Do you understand that concept? Reasonably necessary.
Yeah.
Okay. In Scott v. Harris, another Supreme Court decision dealing with whether or not the seizure in that case was objectively reasonable, the court talks about how the goal is to determine whether the use of force is reasonable for the aim of preventing the threat. In other words, the Supreme Court has stressed in Scott v. Harris, in Lombardo, in this case, Kingsley that I just cited, that there needs to be a relationship between the amount of force used and the need of the force. Well, what does reasonable necessity mean? Necessity implies necessarily a logical connection between the application of the force and the lawful aim of law enforcement, right? The lawful aim of law enforcement is the prevention of the threat. And the relationship between the prevention of the threat and the need, right, has to do with that logical connection. How is the force relating to the threat? That's what it means to analyze the use of force, right? If force has no logical connection to the lawful aim of law enforcement, that relationship is weak. That's why when I say that this is not some new thing I'm inventing, it's just an absolute entailment of what the Supreme Court has already held. I'm not just making shit up.
So do you want to keep it kind of like zoomed out to explore the disagreement, or do you want to zoom in
let's use
on
examples
in the vehicles?
Let's use examples, and then we'll use Renee Good.
Example. Yeah, I would. Alternative.
So let's use examples. Okay, so these are going to be stylized examples, simplified to show the point, right? That the Supreme Court, again, I'm reading from Kingsley, that they need to analyze the relationship between the need for the use of force and the amount of force used. So take the example, you have a suspect. He is shackled, his hands are manacled, his legs are manacled, and he's lying down on the ground. He is unable to move in the moment. And in fact, all he's doing is just shaking around. And I'm just telling you right now, you know, in this hypothetical, that this person has no chance of escaping, no reasonable chance of escaping the manacles, and that him shaking around the way he is isn't a danger to himself or to other officers, okay? In that situation, you would agree trivially, right? Application of force to restrict, that is to say, let's do like a knee compression to the back, is not justified, correct?
Well, with the contextual factors that you've given me, yes. Mm-hmm. But I also I'm reserving the right to bring up examples where that force could be justified.
Right. Different facts.
But I want to just
the
go
reason
with
I put in
down
those,
the train of thought.
The reason I put those factors in there is to make it easy for you. I understand in the main run of cases that there are going to be other factors that might change that calculus. But this is just to elaborate the point. Now, Connor, why would it be the case that the use of force in that situation would be unreasonable?
So can I add a variable or two? let's
I would like you
assume
to
that-
answer first, and then yes, you can add a variable.
Sorry. So ask the question again, because I
Okay.
was already adding a variable in my mind.
The example is someone who is completely restrained,
Yep.
legs, arms, they can't get out, and they're not in danger to themselves, and they're not in danger to others. And an officer proposes to use like a knee hold on them. In that situation, I'm trying to build block with you. It's not reasonable for a lot of reasons, but there's an obvious one, right?
I'm gonna say it's not reasonable to put your knee on the person's neck or back. Shouldn't put it on the neck anyways.
Yeah.
But you shouldn't put your knee on the back unless there's additional variables.
Right, but you make an assessment right there. In virtue of what is it unreasonable? I'll give you the answer from me, and you tell me if you disagree. I think it's unreasonable, given A, there's no qualifying threat to prevent. Right? You're not preventing anything by using the force, right? So at a bare minimum, right, there's no lawful aim there. It's not like you need to move this individual. It's not like you need to administer some medicine. There's no lawful aim, right? That's number one.
Yeah, that's actually, those were some of the addendums and caveats that I was going to add, actually.
Yeah. So
hold on, real quick. Can you just follow me for a second?
Mm-hmm.
So you give me the exact same scenario, okay? Secured suspect, let's say he's on his belly, we're on the side of a road. Now, typically you're not going to restrain his legs on the side of a road. That's more of like a corrections thing.
Yeah.
That's more of like in the jail.
Yeah.
But let's just say that we're on the side of the road and it's a highway, okay?
Yeah.
If somebody is wiggling and there's actually like kind of like, oh shit, this person could roll and or wiggle into traffic.
Right, then you can use it, right?
Imminent threat of death or great bodily harm to themselves.
Right. So
then you could use the knee, and you need to be aware of positional asphyxia as well, which you could actually kill the person by causing positional asphyxia. But in that scenario, the threat to their lives through them acting unreasonable would then justify the knee to the shoulder or the knee to the back. Right. Not kneeing them, but putting your knee on top of their shoulder blade and pinning them to the ground so they don't
beautiful.
move.
That's where I was going with it. We're building on this hypothetical, okay? That's where I was next going. So in the first example, there is no lawful purpose that the force is achieving, right? The force isn't achieving
if
anything.
You're in a corrections facility, he's sitting in a cell by himself, he can't hurt himself. You don't have to take him to the hospital, you don't have to take him to court. You're not trying to move him into a different location. You're not moving him from another inmate. Then within that context of him being in an isolated cell, secured, and he's just wiggling around like a little worm, then you shouldn't go in there and knee strike him or sit on his neck or sit on his shoulder blade because there's no law enforcement or other purpose served.
Right. So now we build onto the hypothetical, the one that you added. He's on the highway, and there's actually a plausible case in which he wriggles such that he is going to get in the highway and is a danger to himself or the other officers who have to go and rescue him in whatever they're doing, right? So now we have a lawful purpose, right? So there's a good purpose for the officers to apply force in that situation. I'm gonna now change the hypothetical. Okay. The officer applies the force actually is able to restrain the person, okay? And it achieves the aim of stopping him from going into the middle of the highway and represent a danger to himself or to any officer that tries to save him, okay? Now, the person who's initially on him steps off. He's getting tired or he needs to go attend to something else. And initially the individual doesn't move. Then he starts to move again. Another officer who's watched this entire thing shoots him in the face to prevent him from doing that. Why is that unreasonable?
Because the use of force or whatever is not proportional to the threat. It's not contextually appropriate. If you're trying to save the person's life, then shooting him in the face does the opposite of that. Like, obviously with clues, it doesn't make sense.
Right. In other words, there is no relationship between the use of force in that case and the prevention of the qualifying or the need that the officer is citing to use force in the first place. And what this set of examples does is illustrate the point that the threat itself isn't the only thing you analyze. You analyze, as the Supreme Court has told us in these cases that I cited to you, the relationship between, in addition to other things, I'm not saying it's the only thing you look at, the relationship between the use of force and the officer need. That is what it means for something to be reasonably necessary.
Okay, do you want to move into vehicles or Renee Good?
Let's go into Renee Good.
Okay.
Okay. So here's my contention. Like in the case that the stylized example I provided to you, okay? Assume that there's a qualifying threat. That is to say, the lawful purpose of the officer, that there is such a lawful purpose in preventing serious bodily injury in this case.
Can we articulate that? That way your audience doesn't think that's absurd.
Go for it.
So for instance, let's run down this logic chain. Feel free to poke a hole in it if you don't agree with it, okay? Despite our current hostility to ICE as a law enforcement organization, they are a law enforcement organization invested with detention powers.
Yes.
And if you check out the detention powers of ICE, typically what it boils down to is people have pointed out correctly that they cannot enforce local, county, state laws. They would have to call another law enforcement agency to do so. However, detaining people who are interrupting or harassing or whatever a lawful ICE operation actually does fall under their purview. So rightly or wrongly, I'm not even arguing right or wrong. You know, I'm not even going to argue whether or not honking a horn a block away is an interruption of an ICE thing. But let's just go with the logic that these law enforcement officers invested with detention power have decided that this is an interruption of a lawful ICE operation, and therefore this person is being detained. So at that point, I would argue that the officers who are on scene, regardless of tactical mistakes, regardless of policy mistakes, they believe that they have the right to lawfully detain Renee Good.
And put a little gloss on what he said. I don't grant that it was illegal for them to try to detain them. Even if it were illegal, the Supreme Court has directly told us that an unconstitutional stop that is the predicate factually for another use of force doesn't necessitate that the first unlawful use of force makes the later use of force or the later seizure or search necessarily unlawful. Now, it might play into ultimately some officer created hazard situation, but all I'm trying to tell you is Connor is correct to the extent that he's saying, which I think he is, that just because it is unlawful or determined to be unlawful later on doesn't mean that it wasn't objectively reasonable to use the force in the instance. And further to that, there actually is a decent reason to believe they were entitled, at least for reasonable suspicion, to initiate the stop. And I've not contested that. That's been my position.
People hate it when I say it, but it's true. You can beat the rap, you can't beat the ride. And what I know that I might be distracting us temporarily, but I just want to just play a little bit of tennis with you real quick. Mm-hmm. If it was an unlawful detention, let's say that a judge later determined that a parked car a block away honking a horn is not a sufficient interruption to justify a detention by ICE, that's going to be figured out by a court.
That's later, yeah. That's
not
later.
Figured out on the street.
Yeah, no, I totally agree with that in general. And this is not to be an apologist for ICE. Like, none of what Connor is saying.
We're just talking about how our system works.
Right. From a policy perspective, I believe that there have been vast abuses and civil rights infringements and rights and liberties infringements, including this recent policy that's been unearthed regarding administrative warrants in the context of search and seizure at a home. So this is not to say that what ICE is doing is justified in other respects. It's just for purposes of our analysis to try to make it narrow and make it correct. And I think that that's largely correct. So let's move on, right? So we're at Renee Good. In the Renee Good situation, let's grant that Officer or Agent Ross had a reasonable fear of serious bodily injury. And again, I don't grant that, but let's grant it for the sake of argument, because this is usually what's in the head of a lot of people who are sympathetic to Agent Ross. They are sympathetic to the danger of cars, and they're sympathetic in the sense of split decisions, okay? So they don't want to ever give ground on that there's not a qualifying threat. I believe there's not a qualifying threat, but let's just move past that. And serious bodily injury isn't like just life-threatening stuff. Broken bones can be serious bodily injuries. And so we're not talking about here, and I've never implied that
a laceration, a broken finger, all these things. Like, I know that when we talk about imminent threat of death or great bodily harm, oftentimes people immediately jump to death. But imminent threat of death or great bodily harm, like first responders, the way that we're trained, and I think the way that the law has argued, is like, as a matter of course, first responders take risk of injury or death as a professional risk, okay? But that does not mean that in the lawful execution of their duties, they have to accept the fact that members of the public can just like lacerate them or break their fingers or break their bones
from a legal
or break their
perspective,
legs,
yeah,
break their arms.
Right.
It's a part of the job, but you don't, lawfully, you don't have to accept that from a member of the public in order to better execute your duties.
Yeah, they're different inquiries. Now, when I think a lot of left-wing people say, hey, you took this job, I don't think you should read that as, well, therefore you should abide all risk, but only that any analysis that just only focus on risk without some kind of more measured and scrupulous look at it, that those kinds of analyses are fucked up, because officers unfortunately are accepted to abide certain risks, and they're not allowed to use all kinds of force in response to any kind of risk, but certain kinds of risks. But I do agree with you in the main that in general they're different inquiries. Whether cops have an oath and they've sworn and they've taken the risk, yes they have, is different than whether or not the use of force is justified under the Constitution and other legal principles. Okay.
Well, sorry, real quick, just to inject it into our specific conversation. So for instance, kind of what I'm hearing, you might not be intending this, but what I'm hearing when you're saying that it is not objectively reasonable to let, and maybe we should zoom out a little bit from Renee Good, but let's say that a vehicle is coming at you and you think there's a high probability of it hitting you. If it's at a low speed, or it's kind of turning away from you so you might not get hit, and therefore you discharging your firearm is not like statistically really gonna change the variable of your injuries or whatever, then a law enforcement officer should just accept that there's a possibility that they're gonna get hit, and they can't act because their action is not likely to statistically decrease what's about to happen, and so they basically have to let themselves get run over. That might not be what you're implying, but that's kind of what I'm hearing.
I'm not implying that they need to know the statistics, okay, and that they need to run like a computer, be able to like run 1,000 simulations and calculate the trajectories like the Rain Man or like Cookie from Ned's Declassified with the eye.
Zach Galifianakis and fucking The Hangover.
Yeah, and The Hangover. Yes, that is not what I'm implying. I'm not trying to say that they would need to like run some kind of is it actuarial? I don't know what the thing is when it comes to like death situations, and to do a kind of risk analysis and to find out whether it's a significant risk, you know, using some kind of like I don't know, statistical analysis, some robust framework like that. I'm not suggesting that. I am suggesting, I think you should agree with it, and I think the examples prove it, that an objectively reasonable officer would think that there is some relation between the use of force and a tendency to reduce the qualifying risk. And if you don't think that,
these things should correlate. Yeah, okay. Absolutely.
Right. So this is the most, and the law, it's not just a moral issue. That's what the law demands. The law demands us to look at the relationship, again, here quoting directly from the Supreme Court, the relationship between the need for the use of force and the amount of force used. Yes, that the need of the law enforcement, reasonable necessity, that this takes into account a determination as to that relationship. We're using this force for that need. In the context of self-defense for a threat, it's force to prevent the threat. In the context of, restraining someone to administer some court-ordered procedure, it's for that purpose. But that there's a relationship.
There are people getting spicy in my chat one way or the other, where they're calling me an arslur for fighting this way, and they're calling another person is calling you an arslur for something. If we were crafting, let's say that you and I are either legislators or judges, okay? Would you carve out, because I think this is reasonable, would you carve out a violent felony exception for accused officer caused jeopardy? And let me articulate this with an example real quick. Let's say that the crime that Renee Good was committing was not obstructing an ICE investigation or whatever. Let's say that the suspicion at the time was that she was a murder suspect, a rape suspect, a forcible robbery suspect, a kidnapping suspect, or something like that, and therefore the officer is stepping in front of the vehicle not because he's reckless and has a wanton disregard for human life, but because he's actually trying to save said like in something like forcible felony scenarios, you have like broad latitude to use force because it's reasonable that they might be a threat to the public if they escape.
Boom.
Right?
Boom. No, this is, I just want to pause right there. This is beautiful. Why is this beautiful? It's a beautiful example of what the Renee Good case isn't. So, yes,
Yep.
when you have
But
who's,
I'm just saying, like, you as a reasonable person who's trying to legislate or improve society or whatever.
I wouldn't make it per se. I wouldn't make it per se like that. I think that I think the test that the Supreme Court has developed, maybe you would. We have a disagreement there just in terms of like, I sometimes am uncomfortable with per se tests. I want a test to be TOC when it comes to the use of force in this context, so that we can't just have these like big holes where like bad actors can just fit everything in that hole. But in general, I'm okay with that rule being the general rule. Why? And I think that is the general rule. All right. I want to be clear about what Connor just said, regardless of whether it's made by statute. I think the rule that Connor describes is in general what actually is the case. If you have a fleeing murder suspect, their flight alone is sufficient in most cases. I'm not going to say every case. In most cases, to use deadly force. Their flight alone. Okay. Obviously, different situation if you're trying to apprehend him in like a situation where you know he's not going to get away, or where there's obviously that's why it's a TOC. But in the context of a fleeing murder suspect or a fleeing
rape circumstances, for those of you who are not tracking it,
yeah, most of the time the flight by itself represents a risk to the public, and so even if you think that the person isn't an imminent risk right now to you, you think he is to the broader public. And so the use of force in that context is justified in that flight. Yes, agreed. And the similar situations in the Plumhoff case, or in these other cases involving high-speed chases. Scott v. Harris is another example of this, where the person has been like kind of cornered by the police, and he's taken the police on this crazy, insane high-speed chase where they're driving incredibly recklessly. And regardless of whether or not it's a criminal, inherently violent crime that they're running away from, their conduct on the road is so reckless and so dangerous that their flight by itself is the threat, okay? And that informs the officer safety analysis as well. So in the Plumhoff case or Scott versus Harris case, oftentimes it seems very similar because they've just started to move again, let's say, right? And that seems like Renee Good. But you have to understand the difference in that case. The difference in the cases like Plumhoff, etc., where it seems similar because they're starting to move again and they're firing the gun, that TOC is premised both on the need for public safety, also officer safety, but it's informed by this fuckered chase or an inherently dangerous felony, which isn't what we have here. They're distinguishing factors. And so that's why I think what you just said is so valuable, because yeah, I would grant if this were like Scott v. Harris, if this were like Plumhoff, I think the officer would be protected. My contention is it's not like these cases. And that's why I think that we need to analyze, well, what is the lawful purpose of the officer, number one? And I think the only possible rationale that one can offer for the use of force, for the lawful purpose of Agent Ross, is defense of self. That's the only possible one that they can even colorably argue. I think it fails, obviously, given my position. But can you think of another lawful purpose besides defense of self?
What, for the execution of that deadly force?
Yeah.
I mean, well, hold on. So, detention. Okay. Now, I want to be clear about this, though. The way that I understand the vested authority within a law enforcement officer is that a law enforcement officer himself is not, as a human being, like my social security number, my birth date, me as a human being, I am not invested with the power of the court. It's the office that's invested with the power of the court, okay? And therefore, we've established a society in which if an officer of the court detains you, you as a citizen pretty much have the responsibility to surrender to that detention and then go through the process so we can avoid the violence and mayhem of fleeing and eluding and resisting without violence, resisting with violence, like all the mayhem that happens during use of force scenarios is actually supposed to be prevented by a citizen surrendering. And so you're saying, what's the lawful purpose
To use your gun
behind this action?
I don't think detention can be it, and I'll tell you why.
Well, no, but I think to an effective detention, we have to ask about like reasonableness of the use of force in order to effect a detention. But we do understand that law enforcement officers effect detentions all the time.
I agree.
With different variations of use of force.
I agree.
So hold on. Just let me finish the sentence and then you can tell me where I'm wrong or where you would amend what I said. The lawful predicate is that we have a reasonably believed lawful detention. And typically, officers of the court are invested with the capacity to detain anyone as long as they are reasonable in said detention. And so at that point, standing in front of the vehicle, by the way, if a vehicle was shut off or if it was parked in a different direction or whatever, there's no law stating like a law enforcement officer can't stand in front of a vehicle. There's no law that a law enforcement officer can't stand in front of a running vehicle.
You're fighting a ghost, Connor. I haven't said that.
Okay.
I'm not invoking.
I'm trying to preempt shitty arguments.
So let's not. But let's not try to predict where I'm going. Okay. I'm trying to listen to you.
I think detention is something that allows the officer to engage in an attempt to detain.
I agree with that, but that's not what we're talking about. The question is the use of force.
Let's try to differentiate because I think I am a little bit lost in your logic.
All right. So we're trying to justify the shots, the gunshots. Okay.
Okay.
And the gunshots aren't.
Hold on. Let's back up one step and then let's move to your step.
Okay.
Okay. There is policy stating that a law enforcement officer cannot or should not stand in front of a running vehicle because of the risk to himself, right? I don't even know if Wick pulled up the right policy, but he pulled up a policy on one of his panel shows that was saying that it's like stated policy from DOJ or whoever that basically like whenever possible, do not stand in front of a running vehicle due to the risk to law enforcement officers, right? That's like a stated policy, okay?
Yep.
However, there's no law stating that a law enforcement officer cannot stand in front of a running vehicle.
Agreed.
Right? Okay. And so at that point, he could be violating policy, but if there was a running vehicle and Renee Good is in the vehicle and they're 3 feet away, and instead of shooting her in the face, he just says, "You're under arrest, please exit the vehicle." Okay?
Mm-hmm.
He's violated policy, but he's still trying to effect a detention, right?
Agreed.
Okay, so let's move on from that because what I would argue is,
well, I wasn't on that.
Up until him pulling and firing the weapon, that's the legal, maybe not the policy world, maybe not the moral world, but that's the legal world in which we exist.
This is what you're trying to do. You're trying to ignore the situation that he's in front of the car, but you can't because it's TOC.
I'm not.
No. Okay. So like, I agree with you. We're not examining whether or not he broke the law by standing in front of the car, and I agree. Right. I don't think he violated the law by standing in front of the car. But
hold on, I'm gonna say this: Beef Supreme, stop being a smug bitch. Okay, continue.
Okay, so we're not analyzing whether he broke the law by standing in front of the car, but whether or not he broke policy by standing in front of the car may or may not be relevant to whether or not he was unlawful in shooting Miss Good. You need to analytically separate those things.
Yeah. Please do.
Okay. One thing is saying that the liability is for standing in front of the car. No one should argue that, okay? That's stupid. The liability that's being proposed is for shooting Miss Good. And whether or not he's guilty of that in some capacity or liable in some capacity will certainly turn on whether the use of force was reasonable. And whether the use of force is reasonable might turn on the extent to which it was unreasonable for him to violate policy with respect to standing in front of the car. They're different analyses. You understand that? Separate. You're trying to remove the relevance entirely, but unfortunately, we don't know that we can do that yet because we don't know whether or not the TOC will include unreasonably created officer hazards. Okay, that hasn't been decided yet, so we can't remove it from the table just yet. Just like we can't knowingly put it on the table, we can't knowingly remove it yet. It's
which is kind of why I wish they had given us a definitive ruling on Felix versus Barnes.
I still think even if we don't have that ruling, that policy in some respect is relevant, but we're not there yet. But we are just examining whether the use of force in firing the shots was objectively reasonable. And for it to be objectively reasonable, you would need to identify a lawful purpose of the officers, right? And what I'm trying to get common ground on is the only possible justification that someone can offer for a lawful purpose for Agent Ross would be self-defense of himself, correct? And I thought I heard you say, well, no, he could also invoke detention rationale, but not for shooting the shots, right?
So you might know the case law better than me. So let me kick back to, holy shit, 11 years ago now. So if I don't have the exact case law or whatever, then just bear in mind I'm remembering this from 11 years ago. Okay. So that felonies are incredibly easy to commit. Okay, like shoplifting over $300 is a felony, right? And there was either a state level case in the state of Florida, or it was a national level case, and maybe it's even Tennessee versus Garner. I don't remember. But effectively, it was whatever one determined fleeing felons. Okay, because what happened was there was a law enforcement officer. I think it was in Kentucky. I think it was in the early 20th century. But so obviously not Tennessee. But what happened was cops were just gunning down felons left and right. Okay, somebody like shoplifts for $300 or whatever. Now, bear in mind the statutes were probably different back then. But effectively, like, if you're a felon and you run away from a cop, the standard was fleeing felon, like, you know, they stand a hazard to the broader public, therefore we can gun them down.
Okay, but that's not true, though, right?
Well, it's not true, especially after the established case law, but I don't remember if it was at the state level
Connor,
or if it was at the federal level.
I'm sorry, but I'm going to have to ask you to not be a pussy and answer the question.
Sure.
Do you remember the question?
No.
Oh, see, I hate you. Because
I'm trying to elucidate a complex topic, and you're interrupting me to say answer yes or no.
No, I'm not saying answer yes or no. It wasn't.
Yeah, you are.
You don't even remember the question.
You're pissing right now. You're pissing.
Dude.
All right, go ahead.
I'm trying to...
Is detention, can you use deadly force in order to effect detention? In broad, yes. Is it reasonable? No. Are there times where law enforcement officers, for instance, whatever case law that I'm talking about, where random felons were getting shot in the back, but they were non-violent felonies and they didn't stand a broader threat to the public? Before this case law, it was standard to shoot felons in the back. After this case law, it became no longer standard because it wasn't viewed as a reasonable.
But the standard to shoot, even if it was
law enforcement officers are invested with authority in order to detain people.
Connor, you're smart, so you should understand. Even if you grant that it was standard to shoot felons in the back, that the standard of shooting felons in the back, even assuming that were the standard in Florida, wherever you're talking about, isn't premised on detaining them. It's premised on a danger to the public. You understand that? No, I don't. And so let's break that down. The detention means to seize someone by the state, correct? It's to seize someone, yes.
Okay. So the reason why detention, or the reason why law enforcement officers believe that detention was reasonable prior to this case law was that a felon, through nature of being a felon, because felonies used to be more serious, considered more serious a century ago, by virtue of being a felon or somebody who had committed a felony, you are de facto a threat to the public.
Right.
And
no.
therefore you must be detained, and therefore any force can be used to detain you.
On
That
a theory
was the
of public,
argumentation.
on a theory of public danger. Right? It's not to effectuate
Sure,
the
but what does that have to do with whether or not you're lawfully able to be detained? And why can't somebody argue that a woman who's willing to flee and elude from a law enforcement officer while being within feet of them from a lawful perspective, why can't they argue that that person's potentially a threat?
I'm not saying they can't
public?
argue. First of all, let's get out of this can argue, can't argue. We're talking about you, we're talking about me, what we're arguing. And so when you say can argue, can't argue, I'm going to be obnoxious as fuck.
We're talking about what the broader society is arguing, but that's okay.
I don't give a fuck. It's you and me. Let's have a conversation. We're not talking to the communities or broader people. We're talking to you and me. And if you say, well, couldn't someone argue? I'm going to interpret that as obnoxiously as possible in the ways that people get pissed off.
Let me own it then. Let me own it then. I think that in a society that is based off of the rule of law enforcement officers are invested with detention authority and are also invested with detention authority up to and including deadly force. And it is only the context in which those detentions arise that determines whether or not use of force is warranted. The detention authority is never in question.
I'm not questioning the detention authority, okay? I'm calibrating very narrowly to the use of deadly force in this case.
But you just said that it wasn't a law enforcement purpose served or something. You said that the only purpose of the use of force... Okay, fine, then re-articulate it and I'll try to
listen very carefully. I'm trying to identify a lawful purpose to use the force in this case. What would be...
And you're talking about specifically the shots fired.
The shots, okay? I'm not talking about detention. You would agree that in order for the shots to be justified, there needs to be a lawful purpose, right?
Yes.
Okay. And that lawful purpose needs to be reasonable in relation to the force used, right?
Yes.
Okay. So I'm trying to identify potential, by which I mean... This is, now I'm going to sound like a hypocrite, but I do mean this in this way. I think it's appropriate. Potential arguments that people on the other side in favor of Agent Ross would levy, such as yourself, to identify which are those lawful purposes, those lawful needs to which Agent Ross is able to marshal an argument. And I've offered one that people are, the main one that people are using is defense of himself. And I agree that needs to be analyzed. I'm just asking, is there another rationale, such as the need to apprehend him or her, or the need to protect the broader public, that you would say is reasonable in relation to the shots fired? And I'm just going to say the apprehension thing I think is going to fuck you over, because I'm just going to give you a bunch of hypotheticals where the mere apprehension, right? Merely trying to apprehend someone isn't sufficient to use the deadly force. You need one of those other threats to public safety, threats to officers. Because otherwise, you're not going to say it's reasonable.
This might be a moment where we're talking past each other. So I do kind of want to mind map it with my chat if they disagree with me.
Okay.
But I do kind of want to put I want to articulate my view, and then I want to pin it, and then I want to move forward and just try to understand maximally what you're saying.
Okay.
Because what I'm trying to say, is that there is a relatively simple calculus, okay, which is cops are invested with the power of the state. They have the right to detain citizens, and then once citizens resist said detention, they have the capacity to escalate force as necessary to detain said person, okay? Now, I think that is just a blanket true statement. And so when
long as it's reasonable.
Well, I don't well, hold on. This is where we're not seeing eye to eye, and I don't think we're going to be able to reconcile it. I don't think we're going to be able to reconcile it in this conversation, and I don't want to spend 40 minutes arguing with you over it, okay?
What do you think we can't reconcile?
What I'm about to say next.
Okay.
So I think you're saying as long as it's reasonable, which puts an asterisk on that statement, which means that all
On
of
everything.
the detentions have to be evaluated.
All applications of force by the government that are considered seizures must be reasonable.
Yes.
Okay.
Okay.
So that's why I'm putting an asterisk there. And so we're not talking past each other on that. We agree on that.
Okay, maybe I'm inferring something that you're not implying. So let me let me state what I'm inferring, and then you can tell me whether or not you're implying it.
Got it.
So okay, hold on. Let me try to think about how to articulate this where it doesn't
Take your
start a
time.
fight.
There's no pressure.
Okay. What I'm hearing there, because I'm doing a very simple calculus, which is state, power, vested, individual, detention, people must surrender to the detention, then we evaluate force after that fact. I view that as a true statement that is then reasonableness is kind of something that draws back that power so we maximize society's well-being. But reasonableness does not eliminate the right of detention. And let me articulate this just a little bit more, So for instance, let's say that he had gone to the passenger side, given her lawful orders, and she had fled the scene, okay? Nobody's hurt, right? At that point, because it's still true that the state has the right to invest officers with power, and those powers include the right of detention, and detention is necessary for the functioning of a lawful society. At that point, said officer would have the right, maybe even the duty, to write up a warrant saying this person interrupted a lawful ICE operation. This is their driver's license. This is their license plate number. This is video of them violating
Connor, your
said
intuition
law.
is correct. Your
This is
intuition
them
is
fleeing and eluding. Therefore, we are going to detain them at a later time.
your intuition is correct.
You haven't given up the right to do this. You've just used more reasonable force within that right.
The authorities vested to the police, and oftentimes are done through statute, and in the case of DHS specifically, they are the Congress of the people of the United States chose to endow ICE with authority to detain, okay? No doubt about that. They are given authority to detain. But everything is subject to the Constitution, okay? So the ability, the authority of the DHS officers, insofar as it violates the Constitution, is not any actual authority, okay? They don't have authority to violate the Constitution. There could be other doctrines that limit the scope of certain remedies, even if they violate the Constitution. That's a doctrine of qualified immunity, all right? Different doctrine in civil damages. And they're actually, sometimes, you alluded to this actually with one of the things you're saying, which is novel laws. You don't get punished for novel laws. In some sense, that's true with respect to qualified immunity doctrine. In qualified immunity doctrine, you need to have a gross departure from like an already established constitutional right / procedure, okay? That's true in the qualified immunity doctrine, but we're not talking about qualified immunity. What we're talking about is whether the use of force in this case, the deadly shots, the firearm, was justified. And when you're laying out this foundation of authority and escalation of force, I will agree with you that that's how officers are trained. I will agree with you that officers have all of that authority subject to the Constitution. And the Constitution requires that all seizures be reasonable. And shooting a gun at a person is a seizure, okay? So that's what we have to contend with. Agreed on the authority part. I'm not arguing the authority part. Agreed on the affirmative duty of citizens to follow the law. That's, absolutely, she should not have run away. That itself was probably a crime and probably was also the cause of her death in addition to other things.
When you're done, at the risk of looping, I think I can articulate it a little bit better.
Go for it.
Okay, so, excuse me, and I actually don't think you'll disagree with this at all, which will allow us to move forward. So, ICE is allegedly engaging in lawful law enforcement operations. They believe that they have an interruption to their lawfully performed duties, and they're invested with detention power in order to effect an arrest. They approach Renee Good And at that point, at least 2 or 3 of the officers, I would say the 2 or 3 of the officers who are not the shooter, are approaching from one side, and they look like they're on the verge of a detention. They look like they're trying to get her out of the vehicle, detain her, etc.
Yeah, they're attempting to detain her, for sure.
Okay. And then the other officer believes that, oh shit, because he was just like videotaping them before, so who knows if he was using it for evidentiary purposes? Who knows what he was thinking in the moment?
Well, that's a a really big question, Connor, and that's relevant as well. But go ahead.
Sure. So at that point, he should at that moment believe that he has the ability to detain Renee Good. Okay. So at that point, if we think we have lawful purpose, authority, like legal ability to detain, I just want to check those boxes as green, and then we can move into reasonableness.
Okay.
Because I think what's being implied, real quick, because people might be like, why is Connor autistically focusing on this green checkbox?
I thought I granted most of this. So I'm going to go.
Number 1, peak shelter built on cliffs, unreachable to zombies. Number 2, island shelter.
Is it couldn't stop her? You really thought that's what I was saying?
What's that?
That they couldn't stop her?
No. What I think I'm inferring, and bear in mind it is the morning and I'm getting caffeinated, is effectively that, like, because the seizure was unreasonable, like because the
detention
shots
was unreasonable?
fired were unreasonable. Sorry, say that?
Did you think that I thought that because the detention was unreasonable, the shots were unreasonable? I hope you didn't think that.
No, the inverse. So I thought you were effectively saying because the shots were unreasonable, the detention was unreasonable.
That is so stupid that you thought I thought that. You thought I thought that going back in time, that like shooting that happens after the detention is initiated bears on whether the detention was lawful. Do you really think that?
No. So what was implied by what you're saying? And I'm not trying to say that you're stupid or whatever. I'm not trying to imply that I think you're stupid. I don't think you're a stupid man. What I'm trying to say is the blanket statement of, and once again, this is why I think we could put a pin in this and move on. The blanket statement of the state is invested with the authority to detain as long, quote unquote, as it's reasonable.
Yeah, and the detention was reasonable.
That blanket statement, but that blanket statement then says if it's considered unreasonable by some, or some like something like that, then you can basically eliminate the right to detain. And specifically in the Renee Good sense, it almost sounds like that statement perhaps in isolation, but that statement sounds like you borderline don't think that the ICE officers have the right to detain.
So I'm granting.
I'm arguing your points for you, and if we've made it this far, we can move into the.
We can, and I appreciate that. I just think that the conversation will move more quickly, and I respect that what you're trying to do. I think that what your mind is doing is like you're seeing the arguments in a head, and you're trying to, like, in good faith, anticipate perhaps where I'm going and just head it off or something. And so I understand that.
I'm also trying to head off like R-slurred people, dude. Like, I get that you're like a smart guy or whatever, but there's also people who are going to use your argumentation, and then they're going to come to my chat and they're going to say soy shit based off of what you said. You know what I'm saying?
Let me just head it off.
We can move forward.
But I do want to talk about the detention real quick, just so that people understand my position. It might be the case.
Yeah, Beef Supreme already did it. He's like, it needs to be reasonable, or else they lose their detention authority. It's like, dude, they're already doing it.
It might be the case that the detention is ruled unlawful at some point in time. I doubt it, fundamentally, because I think that there probably was reasonable suspicion on some obstruction-related offense that they have somewhere in the laws. So this might be me being presumptuous, because there is right now a live fight on one of the basis of obstruction, which requires force, and I don't think that Renee Good used force directly, and so it's maybe like an implied force. So I'm not sure which statute would give reasonable suspicion or probable cause, but I'm assuming there's something there, and maybe that's me taking the light, like, kind of in favor of DHS and saying, like, I don't really want to get into it. I'm assuming that the stop was authorized. Different question whether the stop was reasonable. It actually can be reasonable and unlawful in some respect, unless for purposes of the self-defense analysis and for the seizure analysis. So whether something is reasonable under the Fourth Amendment as a seizure, and a detention would be a seizure, doesn't necessarily mean that it's legal for other reasons. Okay, so there could be other reasons why a stop is illegal other than the Fourth Amendment reasonability test. Okay, but I'm assuming that they're endowed with statutory authority to make this kind of arrest, and the facts at least give reasonable suspicion to make a detention on those facts. Okay, that's what my assumption is, and I'm not contesting the reasonability of the detention. It could be that it's unreasonable. It could be it's
I made
unlawful.
an inference not stated.
Right. So that's all I'm saying is, I think that people who they're barking up the wrong tree to be like, well, ICE shouldn't even be there in the first place. That's more of a political argument that I probably agree with, but it's not so much bearing on my analysis here. And some lefties even say, well, it wasn't lawful for this, that, or that. I'm not convinced yet, but I'm open to those arguments. But it's not factoring in. Okay, so I'm not analyzing the detention for its reasonableness. I'm analyzing the firearm usage. Okay? Now, the facts and circumstances leading up to the attempted detainment bear on the reasonableness of the firearm usage, but they don't necessarily, like, they're not coextensive, because if assume it was illegal detention doesn't mean that it was a reasonable use of force, and vice versa. It could be both. It could be both, neither, or you know, we don't know for one and we know for another. That's all I'm saying. They don't have a necessary connection with each other. They don't determine each other. They're independent.
I'm with you.
Okay, except for the factual predicates that inform both of them. All right, the use of force, in this case, deadly force, where I'm trying to go with, and I'll just tell you my outline, is deadly force needs to be justified with reference to a need, all right? There's a specific need that the government is using to justify its seizure.
That shit already?
In this case, what I'm saying is the only plausible sounding rationales that the government would have, really Officer Ross would have, Agent Ross, would be defense of self. And I'm asking not a yes or no question, but whether or not you can conceive of other rationales that you think are plausibly reasonable other than defense of self. I'll give you some examples.
Possibly.
To
no,
apprehend.
I would not put plausible, and I think it would be an argument in bad faith.
Okay, cool. So let's stick with the self-defense rationale, right? I'm trying to narrow, not trying to widen.
Sure. Can I give you what I think is a weak argument, and then we can move past it?
Yeah.
So the weak argument would be, if this person, because once again, like, everybody else sees like a 37-year-old woman who says, "Oh, I'm not mad at you,
Here's
honey,"
not a
whatever,
fucking
you know,
weak
and they're just like,
argument.
"Oh, totally safe," right? Like, but that's not how police officers think. And then once she knows that she's being detained, and then she backs up her vehicle and then drives it forward. I think it is a weak argument that should not be taken as good faith. But I think in the course of a legal defense, an officer would argue, well, if she's willing to flee and elude in a reckless way that puts my life in jeopardy, then therefore she's also a risk to the public.
Yeah. So
right.
the
I
reason
think
I don't buy it.
I think it's weak, and I'm not going to die on the hill.
Okay. Yeah. So let me give at least the audience a reason why I don't buy it. I don't buy it because for those defense of others rationale, general public, what we're looking for are reckless violations of the traffic laws. Things like very high speeds, driving into other lanes, you know, you've already hit a pedestrian or done something grossly reckless. You know, it's not enough to just run away to be considered a threat to the public. Now you could say, well, the nature of her driving to in the manner that Officer Ross showed would cause him to think that she would be likely to do it, but that would very quickly swallow the rule. If it were enough to say, well, a flight by itself is enough to get that safety to the public rationale, then you're basically suggesting that most, if not all, attempts at flight would be considered threats to public, such that you could use deadly force. But the intermediate appellate courts,
I don't think it is a good faith or a strong argument.
Okay, yeah. A different case in Plumhoff and Scott v. Harris, where, yeah, they unloaded the mag in that situation after a fuckered chase, after incredibly insane, reckless driving, which
I think to be objectively reasonable, we would need more threatening factors.
Correct. Perfect. All right. Beautiful. I agree with that. I think that's reasonable. So the only we think, and I think we agree, plausible rationale would be defense of self. So we now have the officer purpose, the purpose for the use of force. And so let's follow what the court admonished us to do. The relationship between the need for the use of force and the amount of force used. Well, how does shooting Good in any respect have a tendency in the mind of a reasonable officer to achieve the aim of the defense of Agent Ross?
Yeah. So let's argue statistical probability. Okay.
Okay.
So where I move your way, let's try to analyze them. I don't want to say in a vacuum, but let's try to analyze them independently, I suppose, and then like add them up as a TOC. Okay. So vehicles, even at low speeds, if they hit somebody and run them over, crush their legs, crush their arms, crush their hands, whatever, that is potential imminent threat of death or great bodily harm.
Can be, yes.
Okay.
No doubt.
As a vacuum, or as an isolated variable.
Yes. I grant that can happen. Yep.
Okay. Then we have a officer who is standing in front of a vehicle, arguably through officer created jeopardy. But for bad tactics, adrenaline, whatever you want to call it, violations of policy, he's standing in front of said vehicle, and said vehicle is moving towards him. Okay. Within the action-reaction gap, within the adrenaline out context of the subjective experience of the officer, he can perceive the vehicle and will argue in court that he perceived the vehicle as an imminent threat of death or great bodily harm at himself, at which point he is authorized to use deadly force, right? Now you're asking, and I'm going to answer, how is that actually going to help the situation? How is that actually going to defend?
Let me be clear.
The life.
Why would an objectively reasonable officer in Agent Ross's position think that firing the gun in his position would have any relationship with the elimination of the threat or prevention of the threat, which is what the Supreme Court told us, that is used to justify the use of force in the first place?
Okay. So, as the vehicle is backing up, and bearing in mind that this happened in like 3 to 5 seconds or whatever, drawing and firing and killing the driver, if you believe that it's the driver's intent, or you don't know their intent to hit you with the vehicle, then what you could do is you could kill the driver, and then you could reduce the speed with which they hit you with said vehicle.
All right, let's narrow even further. So you would agree, absent an officer's reasonable apprehension that she was intending to hit him as her conscious object, that it would have no relation to end the threat, right?
But the reason why...
Can you answer that first, and then you can explain?
You're saying that intent has to be present in order for the officer to view that objectively reasonably?
That the use of force, that killing the driver, it would only be reasonable in response in that distance if it was reasonable to think that Renee's Good's intention, her conscious object, was to hit you. Otherwise, there's no, because, and it's not because you're going to stop the hit that's about to come or has come. It's because you're afraid that she might run you over, right? Or like back up into you, right? She's gonna miss you and then back up into you, right?
Sure.
Because you're not going to prevent the threat by shooting her in that context. Agreed? Because the car's going to keep going.
No. I don't. Hold on. Let's deal with intent first, okay? And maybe once again I'm inferring too much.
I want to separate. So we'll deal with the situation in which you reasonably apprehend the intent to run you over. But let's take the situation in which you don't apprehend that intent. That is to say, you don't think she's trying to hit you. Assume that it would be unreasonable. We'll get into the intent part. Assume that it would be reasonable for an officer to believe that she was not trying to hit him, and it would be unreasonable to think that she was trying to hit him.
Let's work with that frame, but I'm going to make the same point. Okay.
Yeah.
Can you cause, in a vacuum, imminent threat of death or great bodily harm without the intent to do so?
Yes.
Okay. So, Renee Good trying to flee the scene while turning her wheels away from the officer, but then accelerating at the same time, her intent on whether or not she's trying to hit the officer actually is not...
Connor, listen to me.
It's an important variable, but it's not the variable
Connor,
that determines whether or not
how does
use of
shooting the
force is
bullet
justified.
at the driver at that distance between Agent Ross and the car have any tendency in the mind of an objectively reasonable officer to prevent him being hit by it in that moment, assuming she
If
doesn't have that intent.
Okay, assuming that she's dead or injured and then therefore doesn't slam on the accelerator, that is a decreased risk of imminent threat of death or great bodily harm compared to if she's still conscious and capable of slamming onto the accelerator.
No. At that distance, it wouldn't stop it, right? The
It
car's going
wouldn't
to keep
stop
moving.
it, but it might reduce the amount of injury or death.
And how? Explain that.
How? Okay, you stand 3 feet in front of my car and I gun it. Okay, that's one scenario. You stand 3 feet in front of my car and I hit you at 2 miles an hour. Can we agree that speed and like acceleration is still going to be, it's going to be a variable that determines how injured you are?
No doubt.
Okay. So if the officer wants to stop, he doesn't, like, let's say that it's a conscious thought. And by the way, I don't even think this is a conscious thought, but let's pretend for a second it's a conscious thought.
Then you have a problem. You have a problem, right?
Well, hold on.
If it's unconscious
let me run it
shooting,
and then you can tell me the problem.
Okay.
Let me run it and then you can tell me the problem. Let's pretend that it's conscious thinking real quick. Holy shit, this bitch is about to hit me with her fucking car. She is either trying to hit me with her car, or she's fleeing and eluding and she doesn't care if she hits me with her car. Therefore, I'm in imminent threat of death or great bodily harm. I'm gonna shoot this woman. That way, if she tries to, like, hopefully she's dead or injured or something, so she doesn't stomp on the accelerator and then cause me greater injury or death than if she's dead. Let's pretend that was like a rational line of thinking.
No, why would we pretend that? I think that's an irrational line of thinking.
Why is it an irrational line of thinking?
Because at that distance, there's no reason to believe that shooting in the first shot, right, would cause her to not hit down on the accelerator for the brief period of time under which the car would be such that you would have any bearing on your injuries, right? In fact, this is where the policy becomes relevant. Part of what's informing the policy and to not shoot at moving vehicles is the notion that these kinds of things increase the risk of whatever's in front of the car, Connor. So just so you're aware, the reason the policies are written that way, this is how the policy is relevant even outside of the context of officer-created jeopardy, is the people who wrote the policy said, except in these like weird situations where, like, for example, you have some intentional madman trying to ram people in, then of course, right, I would grant very easily, that it would reduce the threat. We think it actually increases the threat to have someone who's shot manipulating the vehicle for whatever's in front of the vehicle. But in this case, given where he is in relation to the vehicle,
I agree with this, so I should rebut that in a minute.
But how does shooting him with that first shot, where he's aiming like this, the car's gonna hit him or not? And there's no way an objectively reasonable person would say, oh, well, I'm doing this because I think that it's likely, given that I shoot her, that she won't slam on the accelerator. That's not what an objectively reasonable officer would think. They would think, hey, this car is going to hit me. And unfortunately, right, this gun is not going to stop that. It's too close to me. The car is too close to me.
No. You're using objectively reasonable officer, and yet I almost guarantee you that if we went through a polling of officers and we gave them the exact scenario of Renee Good, where they're in the exact scenario that officer is in, and eliminate the officer cause jeopardy for a second. Let's just say you're 3 feet in front of a car. It's about to flee and elude, or they're going to try to hit you. Can you pull your weapon and fire in the hopes that you strike the driver and it reduces the chance that it's going to injure or kill you?
I'm not letting this happen. I'm not letting this fucking happen.
90% of officers are are going to say, yeah, 100%.
This isn't a polling issue. It's a legal issue that courts determine. You might not like it,
You
but
just said you're appealing to objective reasonabableness of law enforcement officers for actions, and you're not by virtue, not by virtue, not by virtue of your stupid fucking poll that you just proposed, which is obviously so slanted and fucking biased, Connor. Not like that. Yes,
And by the
based
way,
off of
we
what
we
current
by the way,
culture
by the way,
understands
by the
truth.
way, we have a
We'll back
by
up
the
a
way,
second.
by the
We'll
way,
back up
by
a
the
second.
way,
By the way, by
we
the
have an
way, by the
informal
way,
poll
by
that
the
happened
way,
in the
by the
moment, which
way.
is none of the other fucking
By the
officers pulled
way.
their guns. Explain that.
By the way,
Because they weren't in imminent threat of death or great bodily
What?
harm.
But they are allowed to defend their officers
By
for
the
imminent fear,
way.
who are imminently in fear of great bodily harm or serious injury. Why didn't they pull it,
Okay.
Connor? Why didn't they pull it?
Why did they pull it? Probably
Pull
because
up,
they were
bitch.
so in shock that this random chick is going to try to take off from
Okay,
them.
but the issue isn't pull the fucking police department with your fuckered
Pull up.
questionnaire. You're trying to make this anything
No,
but.
that is the issue.
No,
Number
it's-
one, that is the issue. Number two,
No,
I
it's
need to
not.
return to a stupid point that you fucking made.
Oh my
I need to
God.
return to a stupid other point that you made. Hold on. We agree that objective reality. I believe in objective reality. I think that when I die, there's a reality outside of this. However, we do agree that objective determinations are the pooling of subjective experience, right?
In some sense, when I say objective,
right.
it is a reference to an intersubjective belief of reasonability, but
There we
it isn't
go.
by virtue of polling cops.
Okay, I don't want you to worm. I want you to listen to my logic. Okay, you can worm
I'm not
after I've
worming.
made my argument. Okay.
You're worming. He's worming.
So what I'm saying is, objectively reasonable officer. That's the standard that you've brought up for the past hour.
Yeah.
Okay.
Not
So
by
if
virtue
you
of polling
take-
cops.
Believe
Not by virtue of
these-
polling
okay.
cops.
But if you take, well, hold on. But this is where this gets really silly to me, and I feel like you're evading what I'm saying.
Really silly, bitch.
If we took every law enforcement officer in the nation, we have to, like, through reason, just presume that there are reasonable law enforcement officers who serve in the career of law enforcement. And so by taking the poll across the entirety of the United States, I'm not saying that every individual officer is going to be reasonable. I'm saying that we're getting a pulse check on what officers believe is reasonable.
I'm not saying that what
And
you're
so
suggesting.
therefore-
I'm not saying what you're suggesting wouldn't be assuming the question weren't biased and slanted. Assuming the question
I mean,
weren't
you could
a
phrase it however the
fucking
fuck you want, and I still think
assuming
you
the
would get
question
it.
weren't a straw man, like you always try to make and make it sound so fucking insane, and assuming the question
Do a
was
steel man.
Straw
All right,
man.
so here's the question, Connor.
A fucking straw man.
Connor, I'll ask you.
Nationwide.
We'll start the poll with you. If you were in Agent Ross' position, would you shoot her?
Shoot her in the
Hold
face.
on. Let's separate this. I would not have done the poor tactics in the officer-created
Cop
jeopardy
out.
that puts
Cop
me in front
out.
of a moving vehicle.
Cop out,
But if
pussy.
he- No.
Cop out,
It's
pussy.
not a
Cop
cop out
out,
because
cop
I'm going
out,
to answer you
pussy.
directly. I'm going to answer you directly.
Pussy.
If I'm standing in front of a vehicle that is 3 feet away from me and it's about to accelerate and hit me, yeah, 100% I'm shooting.
Okay. I think that's fucking stupid. I think that's crazy. I think it's unreasonable. And the question isn't.
You should just be
pull
trying to
every
like get
cop.
out of the way, not
That's not the
worried
objective
about
reasonability
fucking
test.
killing
I
the
would
thing.
agree.
But you're
What
ignoring
cops have
the
to-
logic of what I'm saying. You're ignoring the logic
What's
of
the
what I'm
logic
saying,
of
and
it?
I'm going to point it out to you right now. If we took, there's probably, I don't know, if we took a look at it and we did 1 million cops, okay? Let's say there's a million cops in the United States of America.
Million.
And if we pull them and we say,
Hey,
hey,
bro, it is a
a
million
car is
cops,
3
huh?
feet in front of you, it's going to accelerate. Do you pull your weapon and fire because it's an imminent threat of death or great bodily harm to yourself?
Yeah, change the
Like,
situation.
Is that
Change.
reasonable?
Yeah,
Just
yeah,
get
yeah,
out
change
of the
the
fucking
situation.
way.
Change
There's
the-
no
the
reason to
complete
fucking
situation,
like
right?
kill somebody.
No. What you're doing is you're trying to make a more defensible, generic
I wouldn't
situation.
even think to pull my
and play
gun.
to
I
the
would
fucking
just
sympathies of
be like,
cops.
this bitch
Correct.
is
Do
trying
little
to
cop
run
shit.
me over. I need to get out of the
You know
way.
what you're doing.
1 million cops.
You know what you're doing.
You're acting like a differentiation is not important, and it's wildly important to the thing. Because if you also ask 1 million cops, is it reasonable to step in front of a moving vehicle while trying to effect a detention? 99.9% of cops are going to say, no, that's incredibly stupid and reckless. So you're going to have to differentiate these things, because when you're saying, because what we did.
Why did they have
what
the
you
policies
and I
against shooting
did-
people?
Hold on, we did this earlier in the, no. We did this earlier in the
This
conversation.
is
What
good
we
law?
did is we walked up to the moment of detention
Oh, there must be
and we
those
said,
mushrooms.
green light, green light, green light, green light.
Red light,
Then-
green light.
What we did is we said, is
You're
it
not
reckless
listening.
and stupid? No. I'm listening perfectly well. Don't.
You're not listening.
I'm listening just
He just
fine.
question back.
I'm listening just. It's fine. Tell me what you think I'm missing that's going to move me your way. Tell me,
recapping.
because I'm not listening apparently.
Yeah.
So tell me the thing that's going to change my mind.
Recapping our agreement on detainment likely being reasonable serves no fucking purpose, Connor.
None.
It is a
Yes, it does.
filibuster.
Dipshit.
It is a filibuster. It is nothing.
It's the
Why
context-
are you
it's the
bringing up
context
the
leading up
detention
to
again
shooting.
and going over our agreement on it? What does that have to do with
God.
anything?
Because you're
did
saying
this
that I'm
bitch come
ignoring
from?
variables by creating an
Jesus.
experiment in isolation.
You're
And I'm
making it
not.
more. You're making it
Motherfuckers
more
just
generic
spawning
than
on
it
me and
is.
shit.
And also, in your generic
Oh,
example,
no. Pause right there, because this is how you're going to show me whether or not you're full of shit and whether or not you're trying to win the argument. Steelman the question.
the question
Steel
is
man it.
that you provided was, what do you think most officers would say in response?
No. You're creating the question. Let's just say that you accept my premise.
What premise?
That
I don't know what you're talking about.
Okay, yeah. I'm going to tell you the premise. Why are you asking what premise when I say, let's say
What's
you
that?
accept my premise? What
Get
the fuck
to
are
it.
you doing?
Get to it.
Yeah. Oh, okay. I have to
What
listen
are
to you
you-
for 45 minutes and agree with you on everything.
What do you think
But
is
the
talking
second I
most?
disagree with you, you get spicy. Shut the fuck up. All right. Anyways,
I'm
let's say
really
that you
enjoying
accept
this
my
live.
premise that within 1 million law enforcement officers that serve nationwide, there's some
Are you
reasonable
watching
guys in there.
Pisco and
And we should
Connor
take a look
fight
at
too?
what they think in order to establish an objectively reasonable standard.
Yeah.
I asked a question,
Pretty funny.
and you said that I robbed it of its
I like
of
these
its original
guys fighting.
context, that it's overly vague, and that it's going to slant the responses in my argumentative direction.
Yes.
I'm asking
Or are you talking
to
about
come
me?
up with a stronger, better formulated question in order to get a better result.
A random
Was it
person
reasonable
in
to shoot Renee good in
YouTube
that
was
situation,
trying to
according to your
find
training
some
experience?
Hytale mods.
No, but then
Okay,
you're
maybe.
remarrying the detention and the officer caused jeopardy back to the scenario.
Okay, but your
Random
example
And
does
that's
person
not what we're
YouTube?
arguing.
But the thing is, the test is TOC, Connor. The test is TOC. Now we can go to a more
Okay, but if
stylized
the test is
examples.
TOC,
We can
I
go for more.
already gave you. I already argumentatively gave you.
I'm
officer
just trying to
created
play the
jeopardy.
game. I'm not
I
looking for
already
mods
gave
already.
you
It's crazy
for
that people
tactical
like this is a
decision
new game and
I
people
already
are already
gave
like
you all of
wanting
those
to like
things.
mod
I'm
it
trying
and
to
stuff.
isolate-
TOC,
I'm trying to
it's
isolate-
not reasonable.
I'm trying to
but in
isolate-
the moment, it is reasonable.
I'm trying
Need
to
to get
isolate
down there.
one specific thing, and we can use these kinds of stylized examples and hypotheticals or even questions for discrete inquiries. But you're blowing up
Also, by
the
the way,
nature.
I think your question is total bullshit.
What question?
So hold on. Saying TOC, would you have shot in Renee Good? Then what's going to happen is every single officer, every single reasonable officer, is going to say, no, I would have never put myself in the situation in the
And I
first place.
came
That's
across
not what we were
your
arguing.
live
What
Hytale
we're
stream.
arguing is
This is
whether or
pretty
not
funny.
once
Oh,
you're
yeah.
already within danger.
I usually
Is
just
it
listen to
reasonable?
politics because
No,
I don't
That's what we're asking.
basically
see,
don't have a
yes,
lot
we
of
are.
people
So-
watching me, so I
we
listen to
went
stuff
one
while
level
I'm
beneath
playing
that,
games.
and this shows me.
So I'm not
this,
really
which is as part of determining
a person
whether
who yaps
Not
it
being
is
my wife. I'm
reasonable.
working with
himself.
you perfectly fine.
I'll
So,
talk to people
as
who
part of
come
our
in my
test to
chat
determine
and
whether
stuff,
it
but I'm
is
not gonna sit
reasonable.
here and like
As part of that,
Just
right? So we
talk
are,
to
in some
myself.
sense, trying to find out whether it was reasonable.
it just feels
in the
weird
moment,
and
right?
uncomfortable.
But as part of that, we're assuming what's out.
Oh shit! What the fuck is?
Is he
Oh my
throwing up?
god!
Is he pulling a Xander Hall?
Oh my god.
What's happening?
Sorry.
Did you just pull a Xander Hall?
No, I have post nasal drip that I'm curing, and it was really gross. But
Okay.
it's
I-
it's good
I
now.
I will listen to you,
Okay.
Okay.
but I also want to double back on a question, and I want to force you to answer it. Okay, so go ahead.
I'm gonna
Okay.
force you to answer
We
this
are,
shit.
in some sense, inquiring
Okay.
into whether the shot was reasonable. Okay. We are.
Why are these things?
As part of that inquiry,
I feel like I guess as
the
soon as I like
specific
open the
thing
lava
I'm trying to
section,
find out is
these
whether an
lava
officer in the position
enemies
of
start spawning
Agent
up in
Ross.
this area.
would think that shooting
I don't
a
play.
gun
I never played a lot of
at the
Minecraft, so I don't know. if
driver
that's
of a vehicle
function
at that
of the
position,
game.
at that speed, in those
We just listen to
circumstances,
them yapping. It's
would
perfect.
have
Yeah,
any relation to preventing the threat
that's pretty much what I like to do.
to Officer Ross. And I think
Weirdly
the answer to
enough,
that is
They're
is-
talking
I know
about
what I'm gonna
the
ask
lady
you.
that got
You're
shot.
cutting to what I'm going to
obviously.
ask you. Okay. You and
Uh,
I can agree.
Pisco's a
that
lawyer,
Renee-
and I think Connor is a or he used to be a
Hold on.
cop.
I don't want to
So they're
volunteer your agreement.
debating
I
this.
want to state this as a fact that I perceive. There's 1,000 Renee goods. Okay. There's 1,000 of these scenarios. They happen all of the time. And so what we need to do is we need to analyze said scenario, and we need to come up with good rules that don't just apply to a TOC analysis of the Renee Good shooting, but are actually good guidance for law enforcement officers and how they conduct themselves across the nation. Okay? So what I'm going to ask you, in good faith, and I would appreciate it if you put some thought into your
Eat
answer.
those goddamn frogs.
Okay? You're saying that if there is...
It's one of those frogs. God, they kill me.
I don't want to say ignoring. Ignoring is the wrong way to phrase this. But you're saying that separate from lawful detention, separate from officer caused jeopardy, if a
He's trying to
vehicle
bait
is
me.
standing in front of you, it is
Oh,
not
fuck, there's another
reasonable
one.
to fire into said
Oh, fuck.
vehicle if they're moving towards you at a slow speed, or they're moving towards you or something like that. You phrase it however you want. I don't give a shit.
No, that's too
But come
general.
up-
No, that's too
come up-
general. That's too general. Like
I
obviously
I feel like you're
some-
copping out. I feel like
obviously
this is a
no.
cop-out.
Obviously
I feel like this is
some
a cop-out. Dude,
obviously-
I'm not lying. You might be arguing or talking in good faith right now. I think this is a total cop-out. I think if you put some time and thought into it, you could come up with either a relatively objective question, or you could even come up with a question that slants your way. Like you could even come up with a question that slants your way, but your inability or unwillingness to create said question, I think is an evasion.
I am not
It's more like an
unwilling.
evasion.
I am not unwilling to create a question. I gave you a question. You're the one who says that question sucks. The better question
what is
is
the question that you
The
would
question
ask
fucking
officers? Please don't. Oh,
sucks.
you just said
you didn't
Renee
listen.
TOC.
You know,
Is
no,
Renee
you didn't
TOC
fucking listen, Connor.
reasonable?
Hey, Connor, don't look at your chat. Don't think about other shit.
I'm not. I'm looking right at you. They're not
listen
pissing
to
me
what
off,
I'm
you
saying.
are.
Did you hear me when I said that the question I'm analyzing is whether a reasonable officer in the position of Agent Ross, would they think that shooting the gun at the driver of that vehicle in that context would have any tendency to prevent or eliminate the threat that would justify them shooting in the first place?
Okay, then I'm gonna isolate two arguments, and I don't want you to accuse me of evasion because I'm not evading at all. I am answering you very directly. Okay? In the scenario in which you're standing in front of a running vehicle that is approaching you, I think an objectively reasonable officer will pull and fire in an attempt to reduce the death or great bodily harm for themselves. I think that is true. I also think that the poor
Can we pause?
tactics-
You're just filibustering.
Stop,
Can we
stop.
fucking
No,
pause?
I'm not
It's
filibustering
so
at all.
disgusting to
I'm
watch you
answering
do
that
this.
question. No. No. I'm not evading at all.
No.
I'm answering your question very directly, and I feel like you're being totally evasive.
You're making it so
You're
generic.
being totally
You're being
evasive,
so
bro.
generic. So we can do
No, I'm
hypotheticals.
not.
We can do hypotheticals if you want. If you know that
No, I'm
that
not.
if
No, I'm not.
so here's
You know
the question.
why? You know why? This is why you're losing.
You know
me.
why?
This is
You know
you're losing.
why?
Because
You know
the
why?
use of
You know
force for
why?
a
You know
vehicle
why you're
approaching
losing?
You
You know
are
why?
allowed to use firearms in order to stop that imminent threat of
So
death or
let's
great
test
bodily
that.
harm.
Let's test that.
The
In every
reason why the
case,
Renee
Connor.
Good
In every
shooting
case,
is
Connor.
bad
In every
is
case,
because
Connor.
of the
In every case,
TOC.
Connor. In every case,
Because of the
Connor.
TOC.
In every
It's
case, yes or
because
no.
of the
In
TOC.
every case, yes or no. Now we're gonna get linearized because you can't be handled to have more room to do the conversation because you'll
You're
just
crashing
filibuster
out.
and you'll monologue. So in every case
Fine,
is using
linearized.
so okay. In every case is using deadly force in response to
You know why?
a vehicle
You know
approaching
why?
justified. Yes or no?
No.
What is
No.
going on
Okay.
down
So in the case, for example,
Scared to
let's
go
say
see what that
10 feet
is.
away, the car's coming right towards you, but the officer knows that the driver is suffering under sleep apnea, okay, or what is it, narcolepsy, and you know the driver is actually not conscious at the moment. Would it be
Oh,
just about shoot the
something
the
dying
person
in
there
the
in that
lava.
situation?
No, but there's an interesting addendum to that.
Okay. What's the addendum? Quickly.
The
Quickly,
addendum
quickly.
is that you can use deadly force against people with schizophrenia and people with type 1 diabetes when they're having a violent episode.
I
So
know,
it's not
but
like-
obviously
so
the difference. Obviously the difference is
stop
that
yelling.
you would
Stop yelling. You're
realize
being a
that
bitch. You know you're being a bitch.
someone with
You know you're being a
narcolepsy shooting
You're
them
being a
doesn't
bitch.
stop the threat, right?
No, and yeah. No,
Yes or no?
it
Which
doesn't-
one is it?
shooting somebody with narcolepsy doesn't stop the threat.
Right.
Because they're asleep at the wheel, right?
Right. So shooting them has no relation to ending the threat, because whether you shoot them or not, the car's going to hit you or not, right?
Correct.
Okay.
What I'm trying to identify with your audience, because your audience is fucking retarded, is I'm trying to identify the fact that intent isn't the sole calculation in this. Okay, continue.
Okay. So another situation which is unreasonable to use force in that context is if you know the force will not have a tendency to reduce the threat because the car is too close to you for it to at all, for a reasonable person to think that it would change either the trajectory, speed, or acceleration of the vehicle in a context in which it's unreasonable to assume that she is intending to hit you. That would also be unreasonable.
I don't think you know that at all.
No, I know, but that's why I'm trying to separate it, Connor, and why you're so immune to it. Put aside for now the perceived intent of Renee Good and just focus on the physics question.
I don't even care about intent.
The physics question. The physics question is...
Yeah, let's talk about physics. I would love to talk about physics. Physics is my fucking favorite.
In that context, shooting Renee Good, the car is already moving. It's already accelerating. And shooting her, it's going to take her time to die, and dead people can press on the acceleration. And this is why they're trained. Officers are trained
shoot them in the fucking
general
face.
not to shoot people in moving vehicles. That's the default presumption. That is the default presumption, among other reasons.
No, you've made an incorrect statement twice now, and I'm going to have to correct you. No, you've made an incorrect statement twice now, and I have to correct you. This is the one that I wanted to come back to. I don't think you could find me a single fucking policy or law or anything with the assertion that you stated where you said the reason why shooting into vehicle policy was written was because of the danger to people in front of the vehicles. I don't think you could find a single fucking policy that says that. Hold on. Let me finish. I've been
why
listening
do
to
you
you.
think the policy exists?
Stop.
It's a random
Stop.
policy. It's random.
And now you're straw manning. You're being evasive and you're straw manning.
What's the purpose of it then, Connor, if it's not for safety?
Yeah, I love how you accuse other people of being bad faith and you're being a bad faith.
What's the purpose if not for safety, Connor? Tell us.
I'm just going to point out that I never said that it wasn't for safety. You made a more specific prescription. Okay, so allow me to articulate this. Shut up.
Allow me to articulate
The
this.
reason why you
He
don't
says
fire
articulate
into
a
moving
lot.
cars is probably for a variety of factors that we've seen borne out in cases multiple times. Number one, hitting a moving object or a moving person is incredibly difficult. And law enforcement officers are not
this
known for their
copper, I need
accuracy.
fucking
Okay, so the increases
steel.
of errant projectiles hitting members of the public
Iron,
when you're shooting at a moving vehicle go up
iron
substantially.
fucking
Not only that, but often in a moving vehicle, the
amazing
person
they're
who's
going
causing
too
the
far
threat
with their
is the
arguments.
driver, but there are unknown people
Yeah, they're trying
in
to
the
get
vehicle.
way deep.
There have
in
been
the-
people who are in the vehicle
weeds
where
and the
people were
most,
shooting
like,
at the driver and
nuanced
they
as
hit
possible.
children or animals or innocent passengers or hostages. That's another reason why the policy was written not to fire into moving vehicles.
Is one of the reasons because a decision was made that actually shooting the driver of a moving vehicle in most cases makes it more unsafe on the road?
Yeah, that's absolutely a consideration.
That's what I'm
However, you
referencing.
saying it's like, no. The confidence
No.
with which you stated that twice now is that was like the primary. Once again, I feel like you're implying
If it sounded like the sole reason, okay, sorry.
No.
I'm
In
gonna
your
correct. I'll
argument,
just correct it.
no,
I'll
no,
correct
no,
it.
no.
I'll
Like that was the
apologize. Wait,
primary
Connor.
and
I'll
exclusive
correct it.
consideration when writing the policy.
Connor,
And that is
I'll correct it.
bullshit.
Connor, I'll correct it. Connor,
Bullshit.
I'll correct it. I'll correct it and move
Trying to
on. Listen,
articulate
this is my
this
correction. When I said that's
point,
the reason they have the
pussy.
policy, if you understood that to be exclusive, that wasn't right. I didn't mean it
Or
to make it
primary.
I didn't mean to make it seem like exclusive. I think a significant reason why they enacted the policy, in addition to what Connor described, is because of the danger on the road itself. That's what I should have said.
Sure.
I'm sorry.
A dead or
Why don't we
injured
move on
driver is
and
more
not
likely
filibuster
to
on this
result-
point for a trillion times?
I'm not filibustering
You
on
are.
this point. You made a series of strong arguments on which the predicate is injuring a driver or killing a driver makes the scenario more dangerous and therefore should
so
never be done in
embarrassing.
any circumstances.
So
I
embarrassing.
never said in any circumstance. Who's doing the straw man now, Connor? I granted in Plumhoff. I granted.
No. You just asserted without evidence twice that the primary reason why this policy
Did
was
I ever
written
use
was because
primary?
the
Did I ever use the word
driver
primary?
is more
Wait,
dangerous on the
did I
road.
ever use the word primary? Yes or no?
No, you
Yes or
didn't,
no?
but you 100% implied it.
Well, I
Yes
said
or
the
no?
reason they did this, and I understand that some people could take that as the
Right,
exclusive.
right.
I understand that some.
everybody
I
in your
understand that
audience
someone.
is just
I understand that
supposed to
uncharitable.
assume the nuance that it's a multivariable calculus.
I understand.
Yeah,
I
yeah.
understand.
that
I
uncharitable
understand.
people
I
could
understand.
Say, oh, he meant the sole and exclusive and conclusive. I didn't mean that, and I'm sorry. I do think that someone could understand that.
No.
I just clarified it.
No.
You're
I'm
now
sure
preventing the conversation from happening because you know you're cooked.
No, I'm sure all your lib, soy,
do you agree that one
grassroots
significant
audience understood that it was a
Fishing
nuanced
trap.
and complex,
Ooh.
multi-variable
Dude, are you
calculus
serious?
for why this policy was written.
So-
It's
so-
bullshit.
Are you
Is
serious, dog?
at least
Are you
is at least
serious?
is at
You
least
should know
one
it's
is at least one significant reason for the policy because of the expectation that shooting someone who's driving a vehicle makes it more unsafe on the road.
Yes,
Are you serious?
Okay.
you're inferring. No. You're inferring
Alright, let's get
that
into one of
because
those.
a injured or dead driver is more likely to get into an accident, therefore an officer standing in front of a vehicle and shooting at them when it's a low speed is unreasonable.
Poison
No,
ivy.
That's your
You are
argumentation.
zooming
Don't
out.
tell me
You
that's
are
your argumentation. That's the
zooming.
argumentation you've been making
so
for
you can't
weeks.
Calm
actually,
the
like,
fuck
get
down.
rash.
Just follow.
You're the one who started the
just
yelling, bro.
Calm
The
down.
fuck?
Follow.
You're the one who started the yelling.
Follow the
You're the one who
chain.
started the yelling.
Follow the
I'll
chain
calm
of
down when I
logic.
feel like it.
Follow the chain of logic.
Follow
We
the chain.
agreed that the use of force needs to have some relation to ending the threat to be reasonable.
So,
Okay?
like a
And the question
beehive.
before us isn't reasonableness at some level of generality
That's a
above
lot of
that.
life
We're
is
focusing in
beehive.
on the inquiry
Give your money
specifically
for it.
as
I
to
mean,
whether
honey,
an officer in
honey.
Agent Ross's position would think that using the force would have any tendency to prevent the threat
force.
that to his serious bodily injury, assuming that were there. That's what we're looking into. I'm asking you to put aside the situations for now where a reasonable officer would think that she's intending to hit him, and just to focus on the situation in which she's not intending to hit him. And I'm asking in those cases where a reasonable
God, there's
officer would think
fucking
she
V's on
isn't
it.
trying to hit him, just assume that. Would it be justified to use force in that context? And the answer is no, Connor. The answer is no because of inertia. The answer
yes.
Okay, so if you knew, so here's the question for you then. Agent Ross in the exact same position,
I don't know what
but
the
Agent
point
Ross
that is.
knows that Renee
Whatever.
Good is having a narcoleptic episode, and the exact same situation happens with respect to the turning of the vehicle. Justified to shoot or not?
No, she's already unconscious.
But okay, why? But hang on a second. I haven't changed anything about the direction of the vehicle and the movement of the vehicle.
Yeah, but
All I've changed
rendering
is
her further unconscious doesn't change the variables at all.
Okay, so how does rendering her unconscious change how you view the threat in this context?
Because depending on the consciousness, okay, so let's isolate this moment. Standing in front of a vehicle,
Isolate this moment.
3 feet ahead of you, it's moving, it's gonna hit you or clip you, okay? You have an option to pull the pistol or not pull the pistol, okay? So you say
Okay.
imminent threat of death or great bodily harm, you're pulling the
Okay.
pistol, okay?
Okay.
Firing into the driver, okay? There is a multitude of variables that can happen once you're firing into the driver. Of
Okay.
course, if you incapacitate the driver instantaneously with a headshot, then they can deadfoot and accelerate, at which point you've made the situation worse. What also can
Right.
happen is you could hit them and injure them, and then they freak the fuck out, and then they realize how crazy and dangerous the situation is, and they slam on the brakes, at which point they don't even hit you with the fucking car.
It's
at
too
all.
close for that to happen, Connor. It's
No,
too
no, no, no,
close
no,
for
no.
that to happen.
You're acting like he has like a helicopter god's eye view of the
No.
mechanics of what's happening. No.
it's-
And
it's too-
here's another
it's
option.
too late
Here's
for
another
the
option
brakes.
too. Hold on.
Late
Here's
for
another
that
option
shit.
that happens: is you shoot at them, they panic, and then in their attempt to slam on the accelerator, because they're in a panic, they miss the accelerator. at which point they hit you with a lower amount of force than original. There's
within a foot or
half
two?
a dozen options, one of which is worse, one of which is the same, and two or three of which,
first of all,
which is better.
I'm not sure that breaking makes it safer if it's making contact with you at the time the shot happens, assuming that
now we're arguing about whether or not it's better to be fully run over or hit with a breaking car.
in that context, I'm not sure
that once this, hold on, you already know this, and I already know this.
This is
you
so
already know this,
pathetic.
and I already
Why don't
know
you
this.
listen?
You already know this, and
This
I
is
already
so
know this, and I'm going to finish
pathetic.
this sentence.
You're just filibustering.
Once we get into this level of analysis, where the arguments about what's possible are so detailed, and not only are what's possible getting so detailed, it's unfolding in a matter of seconds. You already know that the courts defer to the judgment of the officer. You already know that.
So listen. First of all, they consider the
answer's
TOC,
You already know.
and that's not just it's not just the moment of impact analysis. That's what we learned from Barnes v. Felix. It's not just the case that we analyze those 2
This
seconds.
goes pretty funny.
Yeah, it's how you.
At
think
any
there's a
given
meme
moment,
of
at any
meme of
given
where he does
moment,
like
at
a-
any given moment,
It's
in
constantly-
order to arrive at the same analysis that I did, it's how you
Asking
evaded
yes or no
the
questions.
hard question of this conversation.
Let's just
But go
Please,
on.
like,
you're trying to zoom out.
what color is the
And now you're making the
alphabet,
point
yes or
about
no?
deference and about
No, I zoomed in.
in a split second they're gonna, because you can't deal with the specific inquiry that I'm trying to handle right now. And that
No,
inquiry,
I actually gave you
that
4 or
inquiry
5
doesn't turn
specific
that
answers to your specific
inquiry doesn't turn on the court's deference. It's about you and me, not about polling some other people. It's about you and me.
No. This is where you're full of shit, even if you don't realize it. You're saying that you walked me down a specific inquiry and I was unable to answer. I gave you.
Let's
half
get in.
a
No,
dozen
let's get into
answers.
it.
You're
We're not.
so
We haven't
used
got.
to
We haven't gotten
debating
into it.
and arguing that you make up the position of the
We
other
haven't
person.
gotten into it. We haven't gotten into it. I'm trying to
We
get
haven't
into it.
Okay, fine.
And
I gave you 5 answers. Analyze my 5 answers, please.
So you gave
Analyze
some
my
of your answers.
5 answers.
Said it increases the risk. Agreed?
Correct. Yeah, one of them does for sure.
Okay, so I'm going to put you in the position of Officer Ross or Agent Ross.
Agent
In his
Ross.
position, would you have any reasonable basis to distinguish between, in that moment, the situations in which it increases risk and decreases risk?
I didn't let
No.
So you wouldn't have a
Wish this
reasonable
weird that
basis
it
to
does
believe
that.
that it would decrease the risk.
Correct.
So if you don't have a reasonable basis to believe it would decrease the risk, why is it reasonable?
Because you're rolling the dice, because we're arguing this on a webcam, whereas officers are making judgments in the field. So if you have a scenario that is it's not totally outside of your control, it's 1% within your control, or it's 10% within your control, and you can roll a 6-sided die, and 2 out of 6 times it's going to hurt you more. 2 out of 6 times it's going to be the same, and 2 out of 6 times you're actually either going to avoid or decrease injury or death. In those scenarios, 100 people out of 100.
Here's my contention. Here's my contention.
Dice.
Here's my contention. Here's
It's
my
revealing
contention.
to me that you can't let me finish the concept.
No, here's my contention, which is the dice is a D 10,000, and the odds that it helps your situation is like, I don't know, 1.
You're making that argumentation, and I don't think you can back that up with any kind of stats whatsoever.
Well, here's a stat for you, and I'm not talking about stats, but just in terms of common sense day to day. Someone who is like incredibly close to a vehicle that's moving towards them,
Hilarious.
shooting the gun doesn't stop the vehicle.
Correct.
Shooting the person who's driving it doesn't stop the vehicle. Newton's first law of motion: an object in
Incorrect.
motion stays in motion unless acted upon by an outside force.
Correct.
Okay, you're incorrect. There's
Newton's first law of
another
motion?
situation.
These are
No,
all
no, no.
the same.
There's another situation where Renee Good is still alive, by the way, where the officer went to pull their gun, and the mere act of pulling their gun was enough for Renee to go, "Oh fuck," and slam on the
Good life
brakes.
lessons
I don't know
from
why that's
That
relevant to what I just
realm of
said.
possibility
Just
and probability
everywhere,
100%
anywhere
exists.
No, but I'm not
Take a
talking about
life,
taking out the gun. I'm talking about
freeze
firing the
plants,
gun.
animals.
So I don't know how that's responsive to what I just
Yeah,
said.
now you're trying to isolate away from what I'm saying. The fact is that the officer pulling and firing in reference
just
to
go
an
back down
imminent
and
threat of
try
death or
to,
great bodily harm.
Imagine being able to build anything just by thinking
Navigate
about
the
it.
underworld.
Meet Base
Hope I don't get
44, a complete
up
AI creation platform
roads.
made for anyone with an idea and a drive
no.
to bring it to life. Describe what
situation. A reasonable officer doesn't look at the situation and be like, yes, killing Renee Good in that situation significantly lowers my chance of getting hurt. Agreed?
Yeah, but who said that significantly is something that a threshold that you have to meet?
So do you think, so I'll ask you, do you think by yourself that shooting her had any significant decrease in risk for himself?
It could be 8%, it could be 12%, it could
Well, that
be 13%.
would be significant. Wait, those would be significant. Those would be significant.
It would be significant, but it would not be probable. It would be significant, but not probable.
Yeah, I don't think that that's
I went
true.
the wrong
And the
way,
reason I don't
then,
think that is true is because I think the hit is overdetermined, and the odds of gunning it with the dead foot or whatever, the dead leg or whatever on the accelerator, that a reasonable officer isn't going to predict that will happen one way or the other, right? Like that just seems like a total random fucking shit. It can make things worse. It seems like a total crapshoot where like, yeah, I'm not sure that I would think that this would have any tendency to reduce the gunning it threat. But even putting that aside, it's going at enough velocity that if it does hit you, like, what does slamming on the fucking accelerator do to increase the threat or not? I'm not even sure mechanically why that's the case.
As somebody who's like, I don't know, lived in the real world for like 10 or 15 years before I became an online content creator, I think this entire rationale is bullshit. Like, unironically, if we had the ability to respawn, what we would do is you would be the driver and I would be the shooter, and we would run it 1,000 times, and then we would just evaluate what actually happened. Okay, so you could hit me with the car 10,000 times.
You're getting hit 1,000 times, right?
10,000 times.
Well, first of all, he didn't get hit. First of all, he probably didn't get hit.
10,000 times. We could do this, and we could get.
First of all, I just want to be clear. First of all, he probably didn't get hit.
Amount of feet. We could hold on. I'm not done yet. We could line up the exact amount of feet, the exact vehicle, the exact gun, you and me, and run the scenario with 10,000 different inestimable variables within the scenario, and I'm telling you, we would get a variable result. There would be there would be times where Renee Good was injured but not killed. There would be times where she accelerated and she killed the officer by crushing his head. There would be times that she caused a hip fracture. There's times that she would miss him entirely. There's times that the officer would injure her, and then she would panic and slam on the brakes, reducing the injury. There's times where she would get hit in the head, dead foot, and and hurt or kill the officer. We could run it 10,000 times, but I'm telling you, within the context of 10,000 variables, you're allowed as an officer in the lawful performance of your duties, if you think that a certain action is going to reduce the threat of imminent threat or great death or great bodily harm, you're allowed to roll the dice.
If it's objectively reasonable. If it's objectively reasonable to roll the dice. Not if it's 0.00001, right? Agreed?
Okay, but
not if it's wait, Connor. Not if it's 0.00001, right?
Why am I lost?
But there's a pin in here that you either need to acknowledge or your audience needs to think about, and this is what pisses me off. But go ahead.
But you can't roll the dice if it's an extremely unlikely situation that it would have any tendency to reduce the risk, right?
But I said it was significant.
Okay, I understand that you said it's significant, but I'm just clarifying that if it's extremely unlikely to lower the incidence of serious bodily injury, and a reasonable officer would know that, it wouldn't be justified. You're not allowed to just roll the dice just because.
If there was a less than a percentage chance of affecting the outcome, then I don't think a reasonable officer.
Right, and you actually believe that it's more likely than not that it increased the risk against them, right?
It's probably 33, based off of like not having the ability to robustly evaluate the vehicle, the officer, the shooting distance, the acceleration, the braking, all that stuff. Without the ability to lab test this, yeah, I have no predictions about what would happen unless it was robust.
Ask the thing that you want to ask. I'm trying to communicate this concept, and maybe we're just disagreeing on the application.
This is another annoying fucking thing. I think, hold on. I'm going to say something first, and then I'm going to say the scenario, okay? This is what pisses me off about fucking liberals. This is what pisses me off about progressives, okay? You guys think that because you're smarter than the average conservative, Because the average conservative is a fucking dumbass. Like the average conservative is a fucking
True.
Trump cultist who doesn't understand anything. You think you're smarter than
Meteorite.
everybody. But that's not true. Okay? And you think that disagreement, meaning that we have, you and I, as differing people, have a comprehensive understanding of the facts, and then we're disagreeing on the facts. You think disagreement is incorrectness because you are enlightened, moral savants who just understand the world better than everybody else, okay? But this is what pisses me off, is that it's Dunning-Kruger, okay? You think you're smart. You're smart cookie. I would never deny your intelligence.
Smart cookie?
But I think that you have overestimated your understanding of the scenario. You've overestimated your understanding of the mechanics of the scenario, and therefore you're arriving at a different conclusion, and that you're presuming that my disagreement is incorrectness. And that pisses me the fuck off. Anyways, let's move into the topic.
I'm actually like,
Why was that
questioning
even?
my ability to communicate concepts, and so I think I'm not.
No, you're communicating them just fine. I disagree.
Okay, you disagree.
You're
that a
smart.
reasonable
I
officer
stupid.
would think it's an extremely
I
low chance that
disagree.
shooting in that context would have any tendency
I
to lower
don't
the
even
threat.
understand what
I
the
think
fuck
I
that-
think an officer would say that it's a low chance, but it's a significant enough chance to roll the dice, and they should be allowed to do so.
Okay, and then maybe
Smart
that's the
cookie, I'll
disagreement there,
steal that.
because you would grant
You're a
if you
very
had my
smart
belief,
cookie.
then it seems unreasonable. Right?
I really don't even get that.
If you
What's
believe
the,
that a reasonable officer
how
would
can
have
a
like,
cookie
would
be
think it's
smart?
so
What's
the-
yeah.
Me isolating
inanimate
these two
object is
factors, and I know
smart.
that I already know that your argument is going to be TOC, but me isolating these two factors, I think is going to clarify the argument for anybody who's who's unclear. Okay.
was the cookie smart?
In my opinion,
don't get it.
if you are 3 to 4 feet away from a vehicle, and that vehicle is either fleeing and eluding or attempting to hit you with the
Fucking
vehicle,
my head. Oh
an
my
objectively
God.
reasonable officer reasonably
How did I end
could
up
fire
over
into said
here?
vehicle with the expectation that, like we said,
is not
there would be
where
a
I wanted to
variable
be.
amount of results. Some of those would increase danger, some of those would decrease danger, some of those would be neutral. But because there's an imminent threat of death or great bodily harm, a reasonable officer would roll the dice. That argument is in isolation and robbed of the context of the Renee Good shooting. Okay?
Got it.
Within the
doesn't
within the
make any sense
context
at
of the
all,
Renee
true.
Good shooting, there are so many things outside of that in reference to
Find my way
poor
back.
officer safety, poor tactics, ICE even having like conducting itself in the way that it conducts himself, all of those things make the dangerous situation itself unreasonable.
Okay.
Okay.
Now,
So the shooting is reasonable. The TOC is not.
okay, I hear what you're saying. I hear what you're saying. Okay. And by the way, I have a lot of the same caveats about I'm not sure that he's going to be held to justice. I'm not sure that they'll charge him. I'm not sure that they'll convict him. We're just having a conversation between us two. I'm not expressing confidence as to the results. Connor, I'm moving the conversation on. The other two shots. At a bare minimum, before we get into whether or not a reasonable officer
I have
could
a
distinguish.
line for you.
Wait, no. Before we get there, can we at least agree that shots 2 and 3, we're getting some indication that shot 3 might have been the killing shot to the head, the instantly killing shot. Can we agree that shots 2 and 3 bear no relation to reducing the risk?
Sure. Yeah.
Okay. So the
Descriptively.
only thing that would justify shots 2 and 3 is if a reasonable officer could not perceive the change in risk,
Correct.
but a reasonable officer could perceive the change in risk.
No, time elapsed was less than a second, maybe less than 2 seconds.
But the human reaction time for threat assessment, risk assessment, is less than a second. The average is like
No,
half a second, if not lower.
This is where we get into. I would, in order for you to make that argument, we wouldn't even be testing athletes for reaction time. And by the way, like reaction time is separate. Like your ability to perceive and your ability to change your bodily actions
is less
are
than a
2 different
second.
things.
It's less than a second.
No, it's 2 different things. I don't. No.
There's
This
scientific
is where I
tests
was
on
having
this.
an argument. We'll Google
average
it
people.
momentarily. We'll Google it in a second. I want to
Google it.
This was the crux of the Chud logic debate, and so I made a drawing based off of the crux of the Chud logic debate. I'm sharing it with you in the Discord right now.
Yeah.
So this is where I think your conversation broke down. It might not be exactly relevant to what you're talking about, but it is relevant to this conversation as far as like evaluating shots fired. Okay. Because in that conversation, you were saying that each individual bullet will be judged on its context. And what Chud was saying was that, and I'll actually read what I wrote, that way I'm not summarizing it poorly, but what Chud was saying is that if you can articulate a class, let's just call it like a class of threat over a certain elapsed time, all of those bullets are going to be evaluated and treated the same. Okay.
Well, if they're if they bear the same, so yeah, if every bullet is justified under the same rationale and the connection between the shot fired and the prevention of the qualifying ground of shooting is still there, then yeah, the answer is just going to be all of them are justified. So it's going to be the same rationale for each bullet. But so he was misconstruing Plumhoff to suggest that not every bullet needs to be justified. The answer is every bullet does need to be justified, but it's just very trivial and easy to assess them all as justified.
Right. So let's break it down in case I wrote something better than what I just said. Okay. So what I summarized you as saying, and I have a beautiful drawing with bullets on it, is every time a cop pulls the trigger, each individual shot must be evaluated as an individual action / seizure, and therefore each round can be ruled justified, unjustified based on its context. If I was summarizing your perspective, that's how I would have summarized it. Okay.
It's not far off, but I want to caution that I'm not saying that courts will analyze this like bullet by bullet from the perspective of like bullet 1, bullet 2, bullet 3, bullet 4. They can address them all in a summary fashion because in Plumhoff, for example, the threat trivially persists throughout all the shots. But here's the difference here, Connor. You just granted that the threat changed between bullets. So we don't have to argue about that. The only question is, could a reasonable officer perceive the change in threat between what we both identified in that time? That's the only question.
Let's argue that momentarily.
Yeah, we've now just agreed that there was a change in threat from shot 1 to shot 2 and 3. And the only question now, unlike in Plumhoff, is could a reasonable officer perceive the change in threat? Because if they can, the shots would no longer be justified. Agreed?
Okay. Let's analyze and fight about that in a second.
Okay.
Okay. Chud Logic's argument, which if I was to summarize his argument poorly, well, I don't know. In use of force scenarios, law enforcement is trained to fire until the threat is ended, which means that in particularly short instances, bullets will be treated as working off of the same information and context and can be judged as a group. And by the way, I don't think that these statements are mutually contradictory. That was one of my frustrations with watching the debate, was I actually felt like these statements are, they're like, they seem like they're opposed, but they're actually not necessarily that opposed.
Right, but Chud is wrong in saying that I'm wrong. Chud says, you don't have to justify every bullet. You do. You just,
but I think he's inferring what you said, which is that a court will be, they'll say bullet 1, bullet 2, bullet 3, bullet 4, bullet 5, bullet 6.
Yeah, that's because he's
we're going to look at each one of them and evaluate a legal case. And by the way, I think that's what people are inferring based off of you saying that bullet 1 was justified and 2 and 3 aren't. I think that people are already making that inference.
Well, they're making.
I just want to finish the drawing.
I want to be clear about applying the Plumhoff test and the test from Gardner and the test from Graham v. Connor. That yeah, if the threat continues to persist, trivially, you can keep using the force that was justified for the first shot for as many shots, so long as the threat continues to persist and is reasonably apprehended, right? Even past when the threat is real, it's just about the reasonable apprehension of the threat persisting. But we've just agreed that the actual threat has changed between bullets 1 and 2 and 3. Now, I think that they were never justified, but I will say that clearly, to the extent that there was a threat at all in bullet 1, the threat is meaningfully different for shots 2 and 3. And so even in the situation in which you grant that bullet 1 were justified, you now need to look into 2 and 3, because unlike in Plumhoff, a reasonable person would say that the threat changed between bullet 1, 2, and 3. And the question is, could a reasonable officer perceive that real change in threat?
Whit might actually go into the third statement.
Okay.
So what I said applies regardless of whether or not you lean more argumentatively towards Pisco or towards Chud. The elapsed time from perception of the threat of death or great bodily harm, the longer the time to observe, or there's a phrase called OODA loop, observe, orient, direct, and act, react. So the elapsed time from the perception of the threat or great bodily harm or death, the longer the time to observe, orient, direct, and act, the harsher the judgment of each round fired will be. And so what I'm trying to say here...
I agree with that. Like, yeah, those things would make it more of a good case. I just think here we have a sufficient case.
But I want to give you a specific case that applies. Okay. Laquan McDonald. I forget what state it is, but my friend, my chat pulled it up, okay? Laquan McDonald was a gentleman, some Midwestern Rust Belt state, I forget. It might have even been Chicago. But he's walking down the street, and he has a knife, and he's waving it around, okay? And then he kind of charges a little bit towards the officers, but not really. He like runs towards them a little bit, then he runs away from them or whatever.
No.
And so what ends up happening is I think multiple officers decide that it's time to shoot, and they all shoot. But what happens is like 3 of the officers shoot, they take him down, but 1 officer proceeds to continue to unload into Laquan McDonald over the course of like 20 seconds, okay?
Yeah.
And he's taking like carefully placed, aimed shots every 2 seconds. Yep. And his argument was that Laquan McDonald was still making furtive gestures. It looked like he was trying to get up. He still had the knife in his hand, et cetera, et cetera. But what the courts ended up deciding, because he actually was convicted, he got a very short sentence. He only got like 2 or 3 years. But what they said is that he's on the ground. You have time to react. He's already incapacitated. There were other means with which to affect your detention or arrest. And so as a result, it was not reasonable to continue to take well-aimed shots for 20 seconds after the original shooting in order to quote unquote end the threat because he was making furtive gestures and down on the ground, right? And so he actually was found not to be reasonable, criminally charged and convicted based off of the time elapsed, okay? Mm-hmm. So I'm not trying to defer to the courts. I'm not trying to argue with you that, you know, 1, 2, like 2 and 3 shouldn't be evaluated at all. But we should look up like action reaction times right now. Yeah. Because if we look at the shooting where shot 1 goes off, like literally start a shot timer, okay? Shot 1 goes off. If we get to, in my opinion, less than 2 seconds for shots 2 and 3 to go off, I have like a 99%.
Like, is it the rule is 2 second,
like
2 second fun zone
court determination, but at the same time, I think everything that I'm talking about right now, action reaction gap, perceived threat, all that stuff, I think those are the reasons why they would be judged as a class of action and not individual bullets fired.
I doubt that a court will rule that when there is a justification, that there's a 2 second window to do whatever you want in relation to the threat.
I mean, let's go ahead and look up human action reaction.
No. Before we'll get to that. Because I have some idea about this. And
okay, I'm going to mute myself, but I'm just going to Google it while I'm listening.
Okay, I prefer just Google it now, and we can tell me when you're done. I want your attention, Connor.
Go ahead. Go ahead. I will not Google. You have my undivided attention.
For public policy reasons, as well as the obvious fucking issues that would persist, the court, I don't think, is going to create and has been loath to apply a mechanical test such that I think the 2 second rule, any shot within the 2 second of a justified use of force,
I don't think a 2 second rule is formalized.
Correct. And the reason for that should be legion, the reasons for why that would be the case. And so, unfortunately, I think that the question is going to be, would a reasonable officer perceive that action reaction time distinct, whatever you want to say? Would they perceive a change in circumstance in that scenario? And that's going to rely, one, on the physiological ability of humans to react, but then also on the average perception of an officer and what they would do. And I think that the first thing we should acknowledge as a building block is it's physiologically possible to react in that time and perceive a different threat, correct?
No, I actually have to Google that.
Okay, Google it.
Okay, I'm gonna Google. So what I didn't like that happened last week was somebody was saying like reaction times for humans are 200 milliseconds. But what they're really saying is that you can see something that's happening and fire your neuron in order to take an action. Okay, that's what they're saying with, and I don't even know if 200 milliseconds is accurate. I'm gonna have to Google it. So I'm gonna Google that first.
Wait, no,
but that's not what we're talking about.
Any reaction time, if you're trying to be like conscious thought versus unconscious thought, whatever, anything like that is gonna apply to the initial shot too. So you can't say that the timing difference weighs in favor of the risk calculation for purposes of justification in the first shot, but then just say, oh, but the same time disparity doesn't justify the realization in the second and third shot. That seems like you're applying a double standard. You understand what I said?
I'm not really sure how, but let me just Google human reaction time first. I'll put average human reaction time as well. Average 1 millisecond. Neuron firing and returning to rest, 6 milliseconds. Seek time compute. HD 1.7 centiseconds to frame rate of 60 hertz. 15 centiseconds, the human reflex response to visual stimuli. 2.5 deciseconds. The what? Can you read that?
Length of a single blink of an eye.
Okay. Yeah. So let's keep going with that. Average human reaction time is a quarter of a second. Okay. So I think that's what they're saying. I don't know if the blink of an eye or whatever is what he was trying to say, but it looks like a 0.25 decisecond, which is 0.25 seconds or whatever. That is the average human reaction time for visual stimulus. Okay, that's what came up when I Googled
that's
average
less than 2
human
seconds.
reaction time.
And it's less than the interval between the first shot and the third shot.
And sorry, hold on 1 second. But this varies by stimulus type, faster for touch and sound, and individual factors like age, alertness, and training, with experts sometimes achieving 150 mil. Well, we're not going to apply like expert shit, right? Because they're talking about like elite athletes.
Yeah,
okay.
Average human, and
average
it's
human
less than
reaction
a
time.
second.
We got a quarter of a second. Okay, we got a quarter of a second. So, what? How long? I'm going to Google it weird, but it's not because I'm trying to be shady. It's because I legitimately do not know how to. I do not know how to phrase this better. So if you come up with a better phrasing, I'll happily Google it. How long does it take to stop a human action? I don't know how else to phrase it. Yeah, dude. Stopping a human action involves a perception reaction process that generally takes 0.5 to 2 seconds for consciousness. Complex tasks like braking a car. In emergency situations, the average human takes roughly 1.5 seconds to perceive a hazard and the initial response. That's my argument. Sorry, you still with me?
Yeah, I'm with you. I don't know
where
that's coming.
I lost visual. Okay, I'm back.
Okay.
Yeah. So, I mean, dude, you can Google it, but that's my argument there.
I don't know where that's coming from. The studies I have from police officers specifically is, and with respect to gun usage specifically, is much less than 1.5 seconds. It's like
what is your resource saying specifically?
It was some guy brought a study and he's like, this was to try to prove the point that it was unreasonable. And hang on, I'll try to find it real quick. And it was something like much lower.
It could be. Well, hold on. This is another thing, though. Is action is going to be faster than reaction, and what I'm saying is, like, you have to perceive a stimulus, then you have to choose to do an action. And then not only are we talking about that, we're also talking about a corrective action. So we're talking about perceiving a stimulus, taking an action, and then correcting the action that you're already taking. That's what we're talking about. So that's where this is even more mechanically complex than simply doing an action. But for the sake of argument, we could just talk about doing an action.
So this was the study that the person brought to my attention. In experiment 2, in which officers were to fire as quickly as they could once the start signal occurred and to stop immediately when it went off, the average stop time over all 5 trials was 0.29 seconds plus or minus 0.17. The researchers noted an interesting phenomenon in the study in that the officer's first trial, where effort of the officer to stop pulling the trigger took much longer for some officers than in any of the other trials in the experiment. Also, only on the first trial did a number of...
that last sentence? That sounded interesting.
Yeah, the researchers noted an interesting phenomenon in the study in that the officer's first trial, where effort of the officers to stop pulling the trigger took much longer for some officers than in any of the other trials in this experiment, experiment 2 versus experiment 1. Also, only on the first trial did a small number of officers pull the trigger slowly, waiting for the stop signal to come on so they could stop immediately. A separate analysis of the stopping time in the first trial resulted in a stopping time of 0.35 plus or minus 0.25, a median of 0.31, and a mode of 0.33.
So what I would say is, what is the because right there, I don't think that this is analogous. What is
not
the
on all accounts, but you can at least grant it's physiologically possible. Can we at least agree on that? It is physiologically possible.
It's physiologically possible to stop shooting a weapon in, I think your study says, a quarter of a second.
Okay. Yeah, I think that's fair. Now let's...
So, well, I have a follow-up question for that. This experiment sounds like they're telling the officers, we want to test how long it takes you to stop firing. So we're going to give you an order to fire, and then we're going to give you some kind of stimulus or some kind of order that's going to tell you to stop firing, right? And so it sounds like you're already preparing the subject for that eventuality.
No, I agree with that.
In that way, I don't think that this is
so Connor, that's what I brought up when this person brought it into my attention, that this is like a kind of, but all I'm trying to prove initially is that it's physiologically possible. Okay.
It's physiologically possible to stop an action within a quarter of a second.
Correct. Okay. So now the question is it reasonable to think the threat perception would have noticeably changed? And one of my super chats gets to the kind of question I'm trying to ask. How could he retrain the gun after moving during the first shot, but not analyze the threat of the target he shot?
Sorry, can you pull that up again, just so I can read it and not try to meme my way away from it? Please, God, Pisco, ask him, how could he retrain the gun after moving during the first shot, but also not analyze the threat of the target he shot? Okay. Because there is 10, I don't want to say 10,000, that's an exaggeration. There are 7 different things that a human being is doing when they're shooting a gun, okay? And realistically, if you ask me, this is a revelation that I've had after 10 years of working in the security industry.
Sorry. He was reading it backwards. He was reading it backwards, all right? So that's why he read it slowly. It's not because he's stupid. He's seeing the Discord flipped version of it, right? So that's why, because I accidentally on my virtual camera I included the.
I don't even know. How about we've been arguing for 3 hours? How about your chat doesn't be fucking dicks about how long I take to read? How about that? How about eat a dick chat?
I'm defending you. Like, you're having to read it backwards. That's probably why it's.
I don't care if you defend me. Your chat can eat a bunch of wieners. Okay. All right. So, anyways, let's break this down because I'm thinking too. You fucking F slurs. Anyways, all right, let's not violate TOS. Okay. Human beings, after 4 years in the Marine Corps, 4 years in law enforcement, 2 years selling firearms, constantly talking and thinking about this subject, human beings are not built for firearms, okay? We're built to grab a stick or a rock and smash each other in the heads. That's what we're physiologically designed for. Firearms are a really interesting technology because they effectively take the concept of throwing a rock and then they make it really, really, really precise and really, really, really mechanical. And so when you're shooting a gun and you're shooting at a moving target, you're not consciously retraining, I think that's the word that he used, which I would say, like, I'm assuming like training, he means to like follow with the weapon or whatever. How would he like follow with the weapon but not realize that the circumstances had changed while he's making an attempt to aim?
Right. There's enough time for him to like.
Let me elucidate a few more variables, okay? When you're trying to aim a firearm at a person or aim a firearm in general, you're trying to establish sight picture, okay? Which means that you're trying to take the 2 bars in the back of the weapon and you're trying to put the front sight post in the front of the weapon. And if you don't do it with a rifle or a pistol, and pistols are even harder, this is what's happening, okay? With adrenaline. Okay, so you're trying to line up the front sight post with the rear sight post, and especially in an adrenaline out scenario, it's doing this, okay? Then not only are you doing that, you're also trying to line it up with the target, and this target is moving, which is already more complicated. So let's say that I am the perfect shot, and I have ice water running through my fucking veins. So I have perfect sight alignment and sight picture, okay? Now I'm trying to aim at Pisco, but Pisco's moving, okay? What I have to do is I have to use my arms, and it's not a conscious process. I have to track the target with those things as I'm pulling the trigger. And if you're a marksman, like if you're a good shot, there's all sorts of shit you gotta do. Like hand placement, the way that you hold the gun. There's trigger discipline, where you pull the trigger in a certain way to make sure that when you yank on the trigger, you're not pulling the bullet off target. So to believe that a trained marksman is pulling his pistol, and I'm sure if we go with draw time, like if we go to what's the average draw of a law enforcement officer, we're going to add time to this calculus. I could probably get my draw time to around a second, even after doing thousands of draws. I think the average person probably can't draw wait, 1.5 seconds.
Can we just pause? Can we just pause real quick? Because, listen, you say, to be fair with Connor, I like 73rd that Ross was just too dumb slow to change his mind during the shots. He started thinking the moment he started shooting. That's not the question. The question isn't whether Ross did that. It's what an objectively reasonable officer would do. An objectively reasonable officer wouldn't be too dumb and slow to change minds during shots.
No. I disagree with you, and I agree with this chatter more than I agree with you. Adrenaline makes you dumb. It makes you bad. It makes you fat-fingered. It makes you uncoordinated. It makes you emotional. Adrenaline does all sorts of fucked up shit. Can I take a bat? I know we're trying to explore complex topics, but can I share an anecdote with you?
Yes.
Okay. So when I was a law enforcement officer, there was this gentleman who had just been released for like aggravated battery. He'd beaten the shit out of somebody 3 years before. He was a young guy. He had an extensive criminal record, but he wasn't going away forever. And within 2 weeks of him, in my relatively small town, within 2 weeks of him getting released, he pulled a firearm on a teenager. Like, we got a report, hey, this dickhead who just got released from prison, he's pulled a gun on a 16-year-old, threatened to murder them, this, that, the other. So we're looking for this guy, okay? And we play hide and seek with him for probably like 3 months. With this guy in this household. And realistically, since the aggravated assault, he's kept a low profile. So we'll catch him when we catch him. So anyways, we get a call that he's at the local basketball court, and it's like 95 degrees out. And so I'm walking up to a crowd of 30 young black men who are playing basketball. And the second they see me, and they see this, I'm not being racist. They were actually just playing basketball. Okay. So I'm pulling up to the basketball court. Every other officer is showing up. There's 3 or 4 cops who are we're on a perimeter of, and I'm the rookie and I'm by myself. And so they do a perimeter around the entire basketball court. Well, all 30 guys decide that they're going to be effectively like a Trojan horse for him. And they're all going to walk out at the same time. So they all walk out at the same time. And I'm looking at 30 different people, knowing that this guy has a firearm, knowing that this guy has a violent history, knowing that this guy has already threatened to kill someone else. Okay. So as they're walking out of the basketball court, sorry, I'm getting a little adrenaline out just thinking about it. So as they're walking out of the basketball court, I noticed that a guy is wearing a hoodie. No one else is wearing a hoodie. Okay. It's 95 fucking degrees. So I say his name. I say his name and I'm like, hey. And he's like, that's not me. And I already have, because I know that I have a 1.5 second draw time. He's got his hands in his hoodie. Sorry, I'm actually getting adrenaline out just thinking about it.
Do you want to take a break? You want to pause? Are you good?
No, it's okay. It's okay. I'll tell the story and then okay.
Let's take a break.
Can I
have to go to Richard Hanania in 45 minutes anyway. We can take a break, dude.
Well, hold on. I'll finish the story. I'm just burping.
Oh, my bad.
Adrenaline gives me heartburn.
Okay.
Let's finish the topic.
I thought it was a difficult topic. My bad.
No, it is a difficult topic, but nobody's dead. I just have heartburn and adrenaline and blood pressure. So anyways, let's finish the story. Okay. So he has his hands in his pockets. And what happens is the adrenaline gives me tunnel vision. Okay? Meaning that my blood pressure is so high that all I can see are his hands. Okay? And then he does a furtive gesture, and I'm already like a quarter of the way out of the holster. He does a furtive gesture where he yanks his hands out of his pockets. I can see his hands clearly, like clear as day. Okay? But I don't know whether or not he's...
Thanks to everybody. Bye-bye. Catch you probably sometime.